your name, speaker order, and time allocation. And then also when you start, just before you start your presentation, could you just clarify your time allocation to allow Justice Fletcher to time keep accordingly? And then to the respondents as well, if you can also be writing in the chat box your speaker name and time allocation, so that our score sheets reflect the correct names. I will allow the one speaker from the applicant to be doing the typing whilst the first speaker begins with their presentation so that we can save on time. So applicant, Ms. Masejo, I believe you are the first one to speak and address the court. You may take the floor.
Chief Justice, your justices. My name is Masero Mpela, and to my left is my co-counsel, Moloko Mulele, and we will be appearing on behalf of the applicant. I will speak for 10 minutes to address the unconstitutionality of Section 4 of the School's Code of Conduct as it violates the learner's rights to privacy and basic education in line with Section 14 and Section 29 of the Constitution, respectively. My co-counsel will speak for 8 minutes to further address the violation of the right to freedom of expression, right to assembly, and the children's rights in line with Section 16, Section 17, and Section 28(2) of the Constitution, respectively. We will then reserve 2 minutes for rebuttals. This matter concerns an appeal to the Constitutional Court challenging the suspension of 7 learners. The question before the court is whether or not the applicant's right to privacy and basic education were violated. To answer this question, the answer to this question is the content of the School Code of Conduct is indeed unconstitutional as it violates the learner's rights to privacy in terms of Section 14 of the Constitution. The provision is unconstitutional as it violates the learner's rights to basic education in line with Section 29 of the Constitution. The conduct of the respondent in suspending the learners fails to qualify within the factors listed in Section 36, which talks about limitations. We submit that the applicant's right to privacy is violated as the search was unwarranted and because Section 14 of the Constitution clearly states that everyone has the right to privacy, and this includes not having property searched or possession seized. Would
Sorry,
like to bring light. Yes.
Just a quick one. Yeah, you are making a submission correctly so that everyone has got the right to privacy and not to have their privacy, invaded in without any justification. Are there any circumstances in your view wherein the right to privacy can be limited?
No.
Okay, Counsel, thanks.
Just to add on to my learned brother's question, Counsel, are you submitting that the right to privacy is inalienable? So by this, you mean that under no circumstances, even including Section 36(1) of the Constitution, the right to privacy cannot be limited?
Yes.
Okay, thank you.
As it pleases the court, let me continue. The search of the learners' bags and the seizure of their mobile cell phones is a direct violation of the constitutional provision protecting the right to privacy. We argue that the mere possession of a mobile cell phone without usage cannot be seen as a distraction to the learning activities in the school. Thus, we submit that Section 4 of the School's Code of Conduct is not reasonable as it criminalizes the mere possession of a cell phone which does not pose as danger to anyone or the environment of the school. My lords, my ladies, there was no legal justification for the principal to authorize a search of the bags of the learners, and thus this should be seen as intrusion. Would also like to submit to the court that the fact that the applicants brought their cell phones to school does not necessarily mean that their right to basic education should be limited. Counsel, For the applicant, therefore, argues that in line with Section 36 of the Constitution, and also believes that the Principals Act, together with the SGB's decision, are unconstitutional with the provision of Section 36 of the Constitution, in particular with the provision of Section 14 and Section 29(1) of the Constitution. The respondent has violated the right to privacy and basic education.
Sorry, Council, just a quick one from my side. What does Section 36 say?
Section 36 clearly states that the rights in the Section 36(1) states that the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equity, and freedom.
Okay, Council, thank you for that submission. So doesn't that then contradict your earlier submission that, Justice Massey and myself, posed to you?
It is stated that a right in the Bill of Rights can be limited if there is a reasonable and justifiable statement that can qualify within the limitation.
So in other words, you're submitting to us now that the right to privacy in Section 14 can actually be limited?
No. We're still sticking to our case that the right to privacy cannot be limited.
Okay, Council, thanks. We can proceed.
Thank you. My lords, my ladies. My lords, my ladies. It must be noticed that in our courts with Anthony versus Settlers High School and the MEC of Education of KwaZulu-Natal versus Pillay, and also foreign courts such as the American court, which have been considered in terms of Section 39(1) of the Constitution with Tinker versus Desmond's. All the judgment states that, and I quote, all the mentioned cases have constantly interpreted a learner's alleged breach of school rules in terms of causing disruption to the discipline and order of the school. There is no reasonable conclusion that can be drawn that a learner in possession of a cell phone can cause disruption in the school's activities. In addition, there is no evidence that the learners who were suspended were causing disruption in the school activities. It is our strong contention that the application of Section 4 of the School's Code of Conduct is unconstitutional and therefore violated the learner's rights to basic education in terms of Section 29(1). Even though the school has established a code of conduct, the SGB is responsible to make sure that the school's code of conduct is constitutional. And in our case, we submit that Section 4 of the school's code of conduct is not constitutional. In the cases between Anthony versus the SGB of Settlers High School, case of 2002, paragraph 17 says, when promoting discipline in the school, there should be punishment which will derive in a positive direction. Thus, this means that there should be a positive discipline. Taking their right to basic education by suspending them is not a positive discipline. My lords, my ladies, Juma Masjid talks about the best interest of the child in line with Section 28 of the Constitution. The suspension of the learners is not in their best interest. According to a case law of December 2020, which is an unreported case.
Just a quick one also from my side. Yeah, you are correctly submitting to us in terms of the Juma Masjid case that the best interest of the child is of paramount importance. My question is this. What other alternatives was the SGB supposed to do in the circumstances other than suspension?
They were supposed to maybe give them a detention in which they will be taken care of by the teachers, whereby they will be given extra activities in the school that will improve their performance, like giving them extra homeworks and extra study time. So this is then deriving them in a positive direction, which will make them want to come to school more and learn more.
Thank you so much, Councillor. We can proceed, please.
Thank you. According to an unreported case of December 2020 between Moko versus acting principal of Malusi Secondary School, the suspension of the learners will put a hold on their career, and thus we submit. In the case between Satau versus Garvas, Mogoeng said that, and thus we quote, the purpose of limiting a right must be sufficiently important to justify that limitation. My lords, my ladies, there is no relationship between the limitation of the right and the purpose of the limitation, as the suspension was made to discipline the children. As a council, we believe that the suspension is going to affect, rather impact negatively on the learners, and we all know it too. Aware of this fact, the SGB went ahead and suspended them. It is therefore clear that all that matters to the school's leadership is the pass rate, but not the development of the learners. If it pleases the court, I may now give my remaining time to my co-counsel.
May it please the court, as my co-counsel has said before, my name is Molele Moloko. And I'm going to be presenting the second argument and the third argument together with the prayer of relief. The second question which arises is whether the communication of information by Ms. Khoza in the latter's decision to conduct a search, or the manner in which the search was conducted, breached the applicant's constitutional right to privacy in terms of Section 14. And so we appeal that the respondent did indeed breach the applicant's constitutional right to privacy, as the right to privacy states that everyone has a right to privacy. This therefore means that the learner's possessions should have not been seized and the property should have not been searched. My lords, my ladies, it all now boils down to learners 2, Section 9 of Equity 1 of the Constitution, which was dreadfully breached by the respondent when they decided to call out for an arrest for a fellow student at their school, when based on the assumptions and accusations that they were the ones that banned one of the school properties of the school and the trash cans. Section 4 states that a code of conduct referred in subsection 1 must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. The school didn't follow a proper procedure before suspending the learners, and so is the governing body of the school, which is the legitimate structure of the school. They suspended the learners without sharing their side of the story, and therefore, we appeal before this court that it was a misconduct, as they should have allowed the learners to present their side of the matter and should have given them 5 days notice before the hearing to present their side of the matter and to also call witnesses. The right of children to special protection in terms of permissible limitations of the ICCR right to freedom of expression says that higher levels of restrictions on the right to freedom of expression and information as engaged by conduct affecting children may be justifiable, having regard to the rights of children to special protection under the CRC, which is the Convention of the Rights of the Children. Article 24 of the ICCR says that children are entitled to necessary measures of protection on the part of their families, society, and the state. Article 3.2 also of the CRC requires that parties are required to ensure for the children such care and protection as it is necessary for their well-being, take all necessary legislative and administration measures to achieve this. In summation of our arguments.
Sorry, Councillor.
Yes, sir.
I see that you have correctly referred to the ICCPR and the UN, CRC. Is there any international instrument at the African regional level, that is similar to the UN CRC or the Convention on the Rights of the Child that you are aware of? No, there's not
not one that I'm aware of,
Okay.
but there
You
is
can
a
proceed.
right. Okay.
Okay. Yeah.
In summation of our arguments, counsel for the applicant has established that the SGB's decision to suspend the learners violates the basic right to education in terms of section 29.1 and also establishes section 4 of the school's code of conduct as being unconstitutional. In the premises, we pray before this honorable court.
4 minutes left.
In the premise, we pray before this honorable court to grant an order declaring the following. The counsel of the applicant respectfully requests that may this honorable court not only strike out section 4 of the code of conduct, but to also make an order that the search and seizures were unlawful and the principal together with the SGB are acting unconstitutional. To also rule out that the suspensions were unfair and cannot be subjected to section 36 since the suspension rule was not based on the law of general application. Respectfully presented by the applicants. If there's no further questions, I'd like to raise my case.
Thank you, team. Counsels on behalf of the applicant. We'll hear from the respondent and then we can hear from you finally in your rebuttal.
Good morning, Justices.
Good morning, counsels. You're welcome to. Hold on. Just for clarity, please ensure that audio is only coming out of one device, so we are not listening to an echo.
Is it better now, Justice?
Let me speak and hear myself. Yes, I don't hear myself anymore, so that should be fine. Go ahead.
I'll start. Okay.
Hold on. Your team, if your second counsel can just write out the names rather of both of you and your time allocation in the chat box so that we know how much time you're taking. And then as you start, just start by notifying Mrs. Fletcher how much time you're taking so she can start timing you whilst your co-counsel writes your names.
Before we proceed, presenting judge, I think there's still an echo. I'm not so sure whether from your side or from the team's side. I think, or I don't know, maybe any of us, but there's some echo that I'm hearing. I'm not so sure if I'm the only one. Maybe it's my side as well.
I hear it faintly as well. I think it's from team 143.
Yeah, I hear the echo as well.
Is it better now, Justices?
Maybe just keep going and then we'll see how it goes, if it's not better or not, and then we'll just let you know. Also, I see that your video has frozen. If your network connection is unstable, please just switch off your video and work from audio only. To the other justices, are you also experiencing what I'm experiencing?
Yeah, from my side, presenting judge, they are frozen, but they are back now. I'm not so sure. They might want maybe to switch off one of the devices if they logged in with two, because maybe that's what is causing, a glitch on their side. I think the support colleague did mention the same. I'm not so sure. They seem to be frozen again, Maybe
Okay,
if they can try and switch off their video and then see if they use their audio only, maybe that can be better.
Team 143, I'm sure you were following. Hopefully you were. If you could just switch off your video, yes, thank you. And then if you could start and then we see how it goes, because we are running behind time.
Yes. Okay, I'll start now, Justices.
Yes, you may go ahead.
As it pleases the court, I am Zina Roons here with my co-counsel, Ms. Cindy Selemankai, and we'll be representing the respondent. I'll be speaking first for 12 minutes to address issue 1 and 2, which is the alleged violations of sections 14 and 29 of the Constitution based off section 4 of the School Code of Conduct. My co-counsel will be speaking for another 8 minutes to address section 17 of the Constitution and how the school governing body's decision to suspend the learners does not violate this right, and to conclude. Would the court find a brief summary of the facts helpful?
No, thank you, respondent. It's not really your job, and the applicant has set the scene, so you can continue with your responding.
The question before the court is whether Umjondolo Combined School violated the learners' rights to privacy and basic education in terms of sections 14 and 29 of the Constitution. The second question is whether the school governing body's decision to suspend the learners is unconstitutional and violates the rights of peaceful assembly in terms of section 17 of the Constitution. In response to these questions, we, as counsel for the respondent, will prove why none of these decisions are unconstitutional. If it pleases the court, I will now continue to address the first 3 issues. Turning to the first issue, which is whether section 4 of the School Code of Conduct is unconstitutional. Umjondolo Combined School added this new rule to prohibit the use of cell phones on school premises. Any learner found with one will have it confiscated. The respondent disagrees with the applicant's charge that the School Code of Conduct is unconstitutional. It is a well-known fact that learners all around the world use every opportunity to be on the cell phones. Thus, they are constantly on social media during lessons, making it difficult for the educator to teach. Section 8.2 of the South African Schools Act states that a code of conduct should be aimed at establishing a disciplined school environment, and we agree that the rule put in place aimed to create a focused classroom environment and was thus successful. Cognizant of Section 36 of the Constitution, we argue that for the learners to receive their deserving education, that the Code of Conduct must reject this harsh punishment or suspension, because the only way the school could have the learners follow this rule is for the punishment to be consequent. It is clear that the respondent was only working in the best interest of the learners. They were being disobedient, and these measures had to be enforced to ensure that no one's future would be negatively affected. Counsel for the respondent hereby submits that Section 4 of the School Code of Conduct is not unconstitutional. If there are no questions on the first submission, I'll proceed to address the second issue, which is the supposed violation of Section 14, which is the right to privacy of the Constitution. Section 14 of the Constitution states that everyone has the right to privacy. A learner dropped his cell phone in class and it was confiscated. He had a disciplinary hearing which resulted in his suspension. Ms. Kosa realized that the learners might not have been following this rule and ordered a search of the bags. Our honorable friends argue that this is an infringement of their right to privacy, but we argue that this was justified. Ms. Kosa had a reasonable suspicion and was allowed to search any learner. 6 learners brought their cell phones and were suspended. The same could be said had it been an illegal substance or weapon, as these are forbidden items such as cell phones. Therefore, the respondent did not violate the learner's rights to privacy, and it is clear that the applicants were disobeying Section 4 of the Code of Conduct.
Counsel?
Yes, Justice?
Perhaps we could grant your argument that there was no violation of privacy, fair and fine. But what about the best interest of the child with regards to the type of punishment that your client then went on to issue? Doesn't it then violate the best interest of the child principle, especially seeing as it's a constitutionally entrenched principle? Was suspension the correct punishment to put out? What the applicant has suggested was detention. And I'm sure my learned colleagues would agree that it sounds quite persuasive that detention would have been a less restrictive mean of limiting the right to basic education, that is. So why is it justified that your client then applied suspension?
Justice, we hear what you're saying, but we need to think of the other children that are at the school. We can't waste valuable education time on disciplining learners that don't want to follow the school rules.
So to infringe their rights would be the best case scenario to save the other ones.
Justice, may I please consult with my co-counsel?
No, if you don't have an answer, let's carry on with your submissions.
Maybe before we proceed, President Judge, I have a follow-up question on that, because I also have a problem to say, was there no other alternative, short of suspension that the respondent would have perhaps used in circumstances, taking into account that we don't want to limit the right of any learner or the best interest thereof, as the presiding judges say. Was there any other alternative, Counsel?
Justice, my client believes that this was the best option, as a school is a place where you learn valuable lessons and self-discipline. Although less restrictive means could have been used, I will consult my client about that, but the learners are at an appropriate age to understand that all their actions have consequences, no matter how severe they are.
6 minutes left.
Thank you, Justice. I'll continue. Our friends might also argue that the privacy of Eddie's communications was violated, thereby degrading his human dignity. Counsel for the respondent submits that this is not true, as the Criminal Procedure Act allows any policeman to search any person without a search warrant. They of course have to have a reasonable suspicion, and as Eddie aided in the first protest, the police could have been suspicious that Eddie was involved this time. Therefore, his cell phone was searched and his text to Mbali and Crystal was found. It is clear that his right to privacy and human dignity was not infringed, as the police did not randomly search him. They had suspicion that searching him would bring up evidence, valid evidence, and that he was somehow involved with the gathering. That concludes my second submission to justices, and if there are no further questions, I shall now proceed with my third submission, which is the alleged violation of the learner's right to basic education, in accordance with Section 4 of the School Code of Conduct.
Thank you, Counsel. We'll hear from your co-counsel.
Okay, that's fine, Justice.
As it pleases the court, I am Nsmcc and I have allocated myself 8 minutes of this court's time to address the last two issues. Once again, a protest of which no notice was given is held with approximately 100 learners, contravening Section 3.2 of the Regulation of Gatherings Act. These learners had posters degrading his cause's name, violating Section 10 of the Constitution, her human dignity. The learners were also blocking the entrance to the gates during the protest, making it difficult for other learners to receive their rightful education. We can plead that they were the ones violating Section 29 of the Constitution. A fire was started in the administration building, and Tato, Precious, and Apio were arrested, as they were the ones leading the protest the day before. Although no culprits were identified at the scene, we can say that it was circumstantial evidence that led to their arrest. These learners held an illegal gathering because they felt that their suspension was unfair. So we can assume with intent that one of them set the administration building on fire. This is the only reasonable explanation based on the circumstantial evidence, Your Justice. If there are no questions on this submission, I will now be carrying on to address the final submission. The 6 learners say that the school governing body's decision was unconstitutional, as they were only exercising their right to peaceful assembly. But according to the United Nations Convention on the Rights of the Child, Article 15, subsection 1 and 2, it states, State parties recognize the rights of the child to freedom and association and to freedom of peaceful assembly. No restrictions may be placed on the exercise of these rights other than those imposed in conformity with the law, and which are necessary in a democratic society in the interest of national security or public safety, public order, which is what the school was trying to achieve, the protection of public health or morals, or the protection of the rights and freedom of others, which the learners infringed while stopping them from entering the school when they blocked the gate during their protest. These learners did not only go against Section 3 of the Regulations of the Gatherings Act, they went against the law that says a protest has to be peaceful and no violence is to be used. Paragraph 53 of the Harvard case says, When the person who has this right to peaceful assembly has no intention of acting peacefully, that they lose their constitutional protection. And the protest that they arrange,
Sorry,
think,
Council, just a quick one. So from the facts, where do we see the violence? Maybe if you can maybe draw me to the paragraph where we see the violence. Because you are making a submission to us that the limitation imposed by the conduct of your client is reasonable in the circumstances. So maybe we can bring my attention to the place where the learners were getting violent, that then warranted the limitation of their rights as you are submitting.
during their first protest to justices, the beams were set alight and they're also blocking roads. Now, isn't that somehow violent and stopping other people from carrying out their daily routines?
Okay, you can proceed.
Thank you, Your Justice. They could have gone terribly wrong when the gun was set alight. Therefore, the school governing body's decision to suspend them is not unconstitutional. Their right to peaceful assembly, in terms of Section 17, did no longer protect them, as they did not protest in accordance with this right. It is justifiable that each of the learners were arrested and detained, as Section 12(1)(a) of the Gatherings Act states that any person who convenes a planned gathering in respect of which no notice was given shall be guilty of an offence and shall be held criminally liable, and in case of a contravention referred to in paragraphs A to J, a fine may be issued. If there are no questions or further questions on this last submission, I will now proceed to summarize our argument and to conclude. In summation of our argument, counsel for the respondent has established that the respondent did not violate the applicant's rights to basic education, privacy, and peaceful assembly in terms of Section 14, 29, and 17 of the Constitution. Counsel for the respondent respectfully requests this Honorable Court to please declare that the High Court was correct in ruling in the school governing body's decision, as the respondent has violated no rights. Thank you, Your Justices.
Just a quick one from my side again, Presiding Judge, just a quick one from my side to the counsel, to the respondent. Counsel, I hear your submissions, but how about if learners were keeping the cell phones to contact their parents? Should there be a case of emergency? We know that there's a lot of child trafficking, etc., or maybe the school, perhaps finishes late, or the sports, whatever. And so, is it unfair for them to have their cell phones at least off, or maybe in the care of their teachers, even, that
Yes,
we completely ban the cell phones completely? Because, yeah, you can go ahead, please.
Yes, Your Justices, we understand that. But these phones are causing distractions in the school. The learners could, if there was in case of any emergency, they could have asked the teachers, their principal, to please borrow them their phones and make a call to their parents. Thank you, Your Justice.
Thank you so much, Counsel.
Thank you.
Thank you, counsel. On behalf of the respondent, we'll now hear the rebuttal from the applicant.
Chief Justice, Your Justices, I will be presenting our rebuttals. My lords, my ladies, it was not stated in the facts that they were using their cell phones, maybe on social media, during the school activities. Thus, we say that the submission from the respondent is not reasonable. My lords, my ladies, we can't dismiss other learners' rights because of the majority and minority. I mean, after all, the Constitution and the Bill of Rights covers everyone who is a citizen in South Africa. They say the school is a place to learn discipline, etc. The question is, how will they learn if they are then suspended? They will then go to the streets and maybe smoke weed, which is not a good impact in our country. I will now give my co-counsel to submit hers.
May it please the Lord.
Counsels, only one counsel is supposed to submit on your rebuttals.
Okay.
But I'll just make an exception to allow you to submit 1 point of rebuttal.
Thank you.
There is a primary distinction in the act of the Regulation of Gatherings Act 205 of 1993, which is that there is a demonstration and a gathering. A demonstration involves more than one person but fewer than 15 people and does not require prior notice, while a gathering is an assembly, concourse, or possession of more than 15 persons in a public space and requires prior notice. By so saying, we believe that the holders of the rights, which were my clients, were the ones who assembled peacefully as per their right to assembly in terms of Section 17, before the other learners willingly joined the protest for support and caused disruption, then my client had to be the victimizers as they were the ones who started the demonstration.
2 minutes.
By so saying, would like to submit to the court that there is no evidence that our clients were seen at this, were noticed, were identified at the scene of the burning at school. Thus, we submit that the arrest was unlawful.
And
right.
there was no violation of.
Thank you.
Thank
you, agents, on behalf of the applicant. I think the court is now well abreast with your rebuttals. And I declare this court as being adjourned. Thank you so much for showing up to both teams. We are very grateful for your submissions, as well as the confidence, and congratulations for making it this far into the competition. You must be proud of yourselves and pat yourselves on the back, because you're handling issues that take a bit of time to grasp, and you're doing it so eloquently. In the interest of time, unfortunately, I will not be welcoming comments from my learned colleagues, so they will leave their comments on the score sheets. And seeing as everything that needs to be done is done, I'll ask that the teams leave the courtroom. And if I am not mistaken, we are together in the next session, Justice Fletcher and Justice Ndlovu.
That's correct.
Yes,
Thank
great.
you.
All right.
Thank you.
Have a good day.
Sorry, President Judge, they haven't given us their names on the chat. Maybe the second speaker can be doing so. That's so long. I think I can only see the ones for the respondent. I'm not so sure if it's my side or.
Yes, I noted the same. I believe they're addressing it now.
Okay,
and then
okay,
first
thanks.
speak on behalf of the applicant. Whilst that is being done, you can just also notify us of your time divisions so that we can time keep in the meanwhile.
Good day, your justices. I am Lubanga Mlamli. With me is my co-counsel Atandile Mnyaka, and today we appear in behalf of the applicant. If it pleases the Court of Justices, today I'll be taking 11 minutes of this court's time. My co-counsel will be taking 7 minutes of this court's time and will reserve 2 minutes for rebuttals. If it pleases the Court of Justices, may I provide a summary of the facts?
Please carry on without the summary. The court is aware of the facts.
Honorable Justices, today I'll be taking the first issue, which is whether or not Section 4 of the School Code of Conduct is unconstitutional as it violates the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution. My co-counsel will be taking the second issue, which is whether or not the SGB's decision is unconstitutional as it violates the learner's right to peaceful assembly in terms of Section 17 of the Constitution. If it pleases the court, I have two arguments under issue one regarding the privacy and the other regarding education in today's case. As it pleases the Court of Justices, I would like to begin with argument one, if it pleases the court. This argument one, to briefly summarize it, proves the unconstitutionality of Section 4 of the School Code of Conduct with regard to basic education. We therefore submit that Section 4 of the School Code of Conduct is unconstitutional as it reads. The use of cell phones, whether on or off, by learners on school premises is prohibited. Any learner found in possession of a cell phone shall have their phone confiscated and may be suspended. Your justices, at a legislative level, we therefore, in this essence, we therefore submit in legislative levels, we submit Section 8, subsection 2 of the Schools Act, which states that the principal or his or her delegates may randomly search a group of learners for any dangerous objects or illegal drugs if a fair and reasonable suspicion has been established. And we therefore refer this court to Section 1 of the Schools Act, which defines these terms. Section 1 of the Schools Act defines a dangerous object as a firearm or any explosive device, and an illegal drug, as it is self-explanatory, is something that is intoxicating in today's case. And we submit that, therefore, since a cell phone is not does not meet the criteria of being a dangerous or either an illegal drug, then the searching done by the respondents towards the applicants is unconstitutional as it pleases the court, as it also violates the learner's right to privacy. We therefore...
Contextually speaking, wouldn't you agree that a cell phone, maybe not equally dangerous, but quite dangerous in the sense that this is an environment and a space for education? To have such distractions in this environment is as dangerous as having weapons in an environment. Allow me the indulgence to equate a cell phone to a weapon of mass destruction. But really, when looking at the future of the pupil in question, it really is a weapon of mass destruction for their future. So don't you think that a cell phone is a serious offense to have?
As it pleases the Court of Justices, we submit that a school code of conduct must be in correlation with the Schools Act and mustn't decide what it thinks or what it assumes a dangerous object is. It should rather follow the guidelines or the right definitions that the Schools Act provides in this case.
Sorry, Council, just a follow-up question, and thank you so much for that response. But isn't it after a consultative process between your client and the respondent, the SGB decided to introduce a code of conduct, So you consented to this code of conduct. And now you are coming to this before us and you want us to declare this conduct unconstitutional, in the court rather. What's your comment on that?
To answer your question, Your Justice, we submit the Bakazia versus Nathan case, where it was stated that consent to a contract can be declared invalid if the contract itself is unconstitutional. And since we have established that Section 4 of the School Code of Conduct violates the learner's rights to peaceful assembly, then it shall be the consent of the learners must be deemed invalid in this case, as Section 4 of the School Code of Conduct is in fact unconstitutional as a whole if it pleases the court. We, the counsel of the applicant on constitutional level, submit Section 14 of the Constitution that states that everyone has the right to privacy, which includes not being searched and having your possessions seized. And we submit, Your Justices, that since the teachers and Section 4 of the School Code of Conduct since the teachers physically searched the learners in this case, and Section 4 of the School Code of Conduct clearly promotes the confiscating of the learner's cell phones, then we submit that Section 4 of the School Code of Conduct must be deemed unconstitutional as it violates the learner's right to privacy in terms of Section 14 of the Constitution. We therefore, in international level, Your Justices, submit Article 16 of the United Nations Convention of the Rights of a Child, which states that no child shall be subjected to unlawful interference with his or her privacy, and the child has the right to the protection of the law against such interference. So to further drive this point, Your Justices, since we have established that the phone is not dangerous and we've proved that the searching of the learners is indeed unconstitutional as it doesn't fall on or go in hand with the Schools Act, then this international law further drives that Section 4 of the School Code of Conduct is indeed unconstitutional, as it further encourages or stipulates that the learner's privacy must be interfered with. And in summation of the first argument, Your Justices, we submit...
Sorry, Counsel. Just a quick one also.
5
What is the
minutes
status
left.
of international law? What is the status of international law, that you just referred to now? Is the Convention on the Rights of the Child binding on us?
If it please the Court of Justice, may you please repeat your question?
My question is, the convention that you just referred to now, is it binding on the Republic of South Africa?
As it pleases the Court of Justice, we submit Section 39 of the Constitution, which states that international law must be considered in cases like these if it pleases the court. We, as the counsel of the applicant, have come about reasons to why privacy is important to an individual. Privacy, Your Justices, is important to an individual, not only as it is a fundamental right, but also as it is essential to autonomy and the protection of human dignity, serving as the foundation upon which many other human rights are built. And number two, privacy, Your Justices, helps us to establish boundaries to limit who has access to our bodies, possessions, information, as well as our communications, Your Justices. So in summation, basically, Section 4 of the School Code of Conduct, Your Justices, is unconstitutional because number one, it doesn't abide with the Schools Act. Number two, it doesn't abide with Section 14 of the Constitution. Number three, we gave reasons to why privacy is so important to an individual, Your Justices. So moving on to this, if it pleases the Court, Your Justices, I would like to move on to the second argument, which is the unconstitutionality of Section 4 of the School Code of Conduct, this time with regard to basic education. We therefore submit, Your Justices, on legislative levels, Section 9, subsection 1 of the Schools Act, which states that a governing body of a public school may, after fair hearing, suspend a learner from attending a school. And we submit that since no fair hearing or any other hearing was done to the learners in this case formally, then we submit that the suspension of the learners from school premises is unconstitutional in this case. And we submit the od alterum partem notion in today's court that learners, rather than the school suspending the learners at first instance or at first violation of the school rules, we submit that the school should, in this case, let the learners at least voice their opinions, or rather stand up for themselves and provide necessary things that will in fact benefit them, and not just being arbitrarily being suspended from school premises if it pleases the court. We, therefore, on constitutional level, submit Section 29 of the Constitution, which states that everyone has the right to education, including adult basic education. And we submit, Your Justices, that if there is some sort of certainty on Section 4, if it pleases the court, Your Justices, since we see that there is some sort of certainty on Section 4 of the School Code of Conduct, and we see that in this case, that level of certainty was not applied to the applicants in this case, then we submit that Section 4 of the School Code of Conduct is in fact violating the learner's right to education, as the learners are entitled to that right if it pleases the court. We, therefore, on international levels, Your Justices, submit the 6th edition of the Bill of Rights Handbook of the Constitution of the United States, which states that a limitation will not be proportionate if less restrictive means could be employed, and that if less restrictive means do actually exist, then the less restrictive means must be preferred instead. So we
Sorry, Counsel. What is the status of the law that you're referring to now? Because you are referring us to the laws of the US now. What is the status of that law in our jurisdiction?
We further submit, Your Justices, we again submit Section 39 of the Constitution, which includes, which states that international law must be considered in cases like these, if it pleases the court. So we submit, Your Justices, that since
sorry, are you saying that the laws of the US are considered international law in your view?
If it pleases the court, Your Justice, may you please repeat your question?
I'm saying that in your view or in your understanding, are the laws of the United States or any other country considered for international law?
If it pleases the court, Your Justices, we actually do submit that laws from other countries must be considered as international law if it pleases the court.
Okay, thank you so much.
We submit that since less restrictive means were actually available to the school in this instance, then we submit that the school should have taken those less restrictive means and implemented them, either than just jumping the gun or jumping to the last resort, which was suspending the learners in this case, if it pleases the court. We therefore submit. If it pleases the court, Your Justices, may I please require 1 minute to finish up my arguments.
No, I don't think it will be necessary, counsel. I'm sure that your co-counsel will be able to cover what you didn't cover. Thank you for your submissions.
It pleases the court.
If it pleases the Court of Justices, as my counsel has already mentioned, I am Atani Lemnyaga, and today, Your Justices, I'll be taking 7 minutes of this court's time and will be addressing the second issue, which is whether or not the SGB's decision is, in fact, unconstitutional, as it violates the learner's rights to peaceful assembly in terms of Section 17 of the Constitution. If it pleases the Court of Justices, I'd like to make my first submission. We would like to submit Section 17 of the Constitution of South Africa, 1996, which states that the right peacefully, unarmed, to assemble, to demonstrate, to protest, and present petition. The right to peacefully assemble shall at all times be recognized. No restrictions may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society. This law was drawn from the United Nations International Government on Civil and Political Rights of Article number 21. With that being said, Your Justices, we would like to submit the case of Mlungwana and other versus another in the year of 2019, Section 1, with of paragraph 2, which states that the Section 12, subsection 1 of the Constitution constitutes an unjustifiable limitation of the right in Section 17, which is the right to peaceful assembly. If it pleases the Court of Justices, with reference to the Satau and another versus Gavas and others, 2013, paragraph 53 of the Constitution. If it pleases the Court of Justices, when we look at the nature of all protests, they are all not peaceful, and as the people who are protesting want to voice out their grievances and show that they're not happy about some decisions taken by people of authority. With that being said, Your Justice,
are you suggesting that the drafting of the Constitution, as well as drafting of international law regulations that deal with peaceful assembly are all futile because peaceful assembly is not possible.
If it pleases the Court of Justice, would you please rephrase the question?
Based off of the submission you just made, counsel, you said that the protest would not be peaceful because people are trying to express their grievances. Are you suggesting that there is no protest that is ever peaceful, firstly? And secondly, when the right to protest and express one's concerns and displeasures was made, and the drafters explicitly said a right to peaceful assembly, they were creating a provision that was never going to be possible to fulfill. Is that what you're submitting?
If it will be helpful to the Court of Justices, I'd like to explain the definition of violence in this instance. It is the intentional use of physical force or power that will result in injury or physical harm of other people. To support that, Your Justices, these learners were unarmed, which means that they never had any intentions to harm the people or even infringe their rights to infringe the pedestrians' rights to movement and learners' rights to education, but instead they limited these rights in order for them to be heard, Your Justices. With that being said, this means that they had no intentions of hurting anyone, but rather making their voices to be heard. And according to the facts,
counsel, are you saying that arson would not harm people? I'm not sure if you understand what I mean by arson.
I'm not familiar with that, Your Justice.
Lighting things on fire, that is what arson is. Are you saying that this is not harmful? Because they had no weapons in hand, but they could light things on fire, they did not mean to harm people. They just wanted to, start a little bit of a fire just to have a bit of fun, in essence.
Your Justice, we would like to submit that it was not our clients who caused the fire in the school grounds. And with that being said, Your Justices, as the police came to inspect the scenes, there were no culprits identified. So this means that our clients were not the ones responsible for the burning of the things of the school, Your Justice, if that answers your question.
Okay, carry on. Thank you.
If it pleases the Court of Justices, I'd like to continue with my arguments. According to the South African 83 of the Constitutional Court of Gore's case, paragraph 61, which states that the right to freedom of assembly is central to our constitutional democracy. It exists primarily to give a voice to the powerless. Indeed, it is one of the principal means by which ordinary people can meaningfully contribute to the constitutional objective of advancing human rights and freedom. Your Justices, as people of color, coming from a history and background with freedom of gathering or demonstration was not a freedom that people of color would enjoy freely. Nowadays, this leaves no room for phobia of people of color to exercise this right lawfully and make their voices to be heard. And in this instance, Your Justices, in the instance of Mjondolo Combined School, this protest was indeed a platform for other learners to voice out their opinions and how they were unhappy about this decision made by the SGB, as more learners spontaneously joined the protest that was held by the conveners, if it pleases the Court of Justices. And with that, we would like to submit paragraph 63 of the Satau and another versus Gavas case, which states that, so the lessons of our history, which inform the right to peaceful assembly and demonstration in the Constitution, are at least twofold. First, they remind us that ours is a never again constitution. Never again will we allow the right of ordinary people to freedom in all its forms to be taken away from them. Second, they tell us something about the inherent power and value of freedoms of assembly and demonstration as a tool of democracy, often used by people who do not necessarily have means of making their democratic rights count. If it pleases the Court of Justices, we would like to submit that the rights of learners to education and peaceful assembly should have been limited in a fair manner, and the individual who is subject to such authority is treated fairly and justly. The suspended learners, Your Justices, were not given a platform to voice out or even defend themselves. Fair procedures during disciplinary hearings serve to achieve the purpose of facilitating accurate information and informed decision-making. It also ensures that decisions are made in a public interest and that important procedural values are followed. Your Justices, if you please.
But sorry, Counsel. Maybe just a quick one. I understand your time is up. But again, you consented to this code of conduct that you're currently challenging. And I did ask your co-counsel earlier to say, now you come here, you are saying to us, we must find this, code unconstitutional, but it was after you were consulted, or your client consulted to, when this code was made. Now, maybe quickly, what's your comment on that? Presiding Judge, don't kill me, please.
To answer the time is up. Justices, we would like to submit with the case of Bakazi versus Nathan, where it was said that the consent to a contract can be declared invalid if the contract itself is unconstitutional. And with that, Your Justices, we submit that the school's code of conduct is indeed unconstitutional in this instance. Your Justices, if it please the court, I would like to remind the court of the rights to the importance of education. Your Justices, education is regarded as one of the most valuable requirements pertaining to global progress and
your time is up. Thank you for your
If it pleases the court, Your Justices, would the court please provide me with 30 seconds just to sum up my arguments?
No, you will have an opportunity to summarize your arguments in your rebuttal. We'll now give the floor to the respondents.
Thank you, Justice.
May it please the court, my name is Murabezi Andisa with my co-counsel Busisiwa Boy, and we represent the respondent. As I've stated before, I'll be speaking for 12 minutes and my co-counsel will be speaking for 8 minutes. If it pleases the court, we would like to give our submissions. We humbly submit that the code of conduct does not violate the applicant's right to privacy and to education. The school acted well within its rights and responsibilities as local parentis in the place of a parent. Council also submits that the suspension of the learners, as decided by the school governing body, does not violate their right to a peaceful assembly, but only limits it as it infringes on the fundamental rights of others. My Justices, in the head of Department of Basic Education, Free State Province versus Welcome High School and another, the court observed, a code must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. My Justices, when a school decides upon implementation of a school code of conduct, it is in the best interest of the learners. My Justices, the school code of conduct does not violate the applicant's right to privacy in terms of Section 14 of the Constitution, as well as infringe on the right to education in terms of Section 29 of the Constitution. My Justice, as per Section 4 of the Code of Conduct, the use of cell phones, whether on or off, shall at all times be prohibited. Any learner that is found in possession of a cell phone will have the phone confiscated and may be suspended. My Justice, this prohibition consists of 3 constituent elements, namely the use of a cell phone, the confiscation of a cell phone in furtherance to possession, and suspension for failure to abide by rules. The use of a cell phone, my Justices, simply refers to possession. Possession is essential a person intentionally exercised toward a thing. Therefore, the applicant was in possession of a cell phone with the intention to use. Stated differently, there must be an intent to control the cell phones in question. The applicant's possession of a cell phone tells us that through human reference that such possession is not subject to unknowing possession. My Justices, the applicant had constructive possession of a cell phone and stands in the same position as a person who is in actual possession of a cell phone and using the cell phone. Therefore, the respondent will rely on this act to infer that the applicants were in possession of a cell phone with the common intention, the intention to use. Therefore, the phone needs to be confiscated. Now to the second element, the confiscation.
Okay, you know, I'm sure you're aware that the Department of Basic Education is trying to integrate the Fourth Industrial Revolution and technology and advancing, learners' aptitude with technology. Don't you think that the cell phone may have been a part of something in the curriculum such that it was to the benefit of the learners to have the cell phones on their persons. And, in addition to that, maybe they had their cell phones with them because after school, they need to contact their parents to ensure that they get home safely, or some sort of, reasonable and justifiable reason in that manner. Did your client take this into consideration when making his decision?
My Justice, the school had no way of knowing whether the learners were in possession of their cell phones with good intention. They would infer to past accounts where the phones were used to disrupt lessons, as learners would spend most of their time on social media. Therefore, the applicant should have gone to the head of the school and notified them about such possession of their cell phone.
But counsel, from the facts, we are told that their cell phones were off, and how do you deal with that aspect?
My Justice, this refers me to constructive possession of the cell phone. Constructive possession of a cell phone means that their cell phones were inside their bags, but they had an intention to use the cell phones. We do not know whether their intention was that to use it after lessons or during lessons. Therefore, would infer to this that such possession is not such to unknowing possession.
But again, counsel, then what about an instance of emergency, wherein the learner was to contact the parent, in case of emergency or change of schedule at school, etc.?
If the applicant had notified the school, maybe such instances would not have happened. Maybe matters wouldn't have panned out the way they did.
So you do consider then that the cell phone, to some extent, is a good instrument to have, even at school, just like the presiding judge is saying that in this era of the 4IR and artificial intelligence, wherein we use gadgets and so forth, a cell phone may be a good instrument to use at school. Are you conceding to that argument?
Yes, if utilized properly.
Thank you so much.
The confiscation of the cell phone in furtherance to possession. A cell phone, according to Section 14 of the Constitution, is private property. My Justices, if it pleases the court, counsel would like to submit to the court the elements of an infringement to the right of privacy. The reasonability of the expectation of privacy. Neither the confiscation nor the search of the school's bags is an infringement. Search, my Justices, where it relates to a person must be given its ordinary meaning. Search, my Justices, may also be regarded as any act whereby a person, container, or premises
6 minutes left.
is visually or physically examined with the objective of establishing whether an article is on or upon such person or container. If there is no expectation of privacy, then no infringement has occurred. The applicant did not have the subjective expectation of privacy, which was objectively reasonable, meaning that they had an expectation of privacy, but their expectation of privacy could not be objectively reasonable. The applicant had no reason to expect privacy, as the school will act well within its local parentis role to ensure the educational welfare of the other learners, as it was aimed at the aim of the search was justifiable, as it aimed at validating a reasonable suspicion of the presence of cell phones on school premises. And as counsel has said before, the school will rely on past accounts to infer that the possession of such cell phones is not subject to unknowing possession. Secondly, the justification of the intrusion. The school had justifiable reasons to confiscate and search for phones, as they would infer to past accounts where phones caused disruptions in lessons, as stated in the facts. My Justices, counsel does acknowledge that the school knowingly confiscated and searched the phones, but the learners were given a notice of the pending matter and thus deliberately went against the code, as stated in paragraph 6 of the facts, which states that Ms. Koza warns that as of the next day, any learner that is found in a possession of a cell phone will have the phone confiscated and will be suspended with immediate effect. With that, counsel will refer to its first element of the infringement where there was no expectation of privacy. Therefore, if there is no expectation of privacy, then no infringement has occurred. The last element of the prohibition on cell phone use is suspension for failure to abide by rules. My justices, according to Section 4 of the South African School Acts, nothing contained in this act exempts a learner from the obligation to comply with the code of the school attended by such learner. This means that the applicants are liable for a misconduct and a breach of the code of conduct. Suspension, your justices, serves as a form of exclusionary discipline. It promotes discipline and successfully modifies misbehavior before it even occurs in other learners. It does not take away the right.
Sorry, Council, but you suspend kids for this long or learners for this long, and you limit their right to basic education, and yet we do have even case law that says a school environment is the best place where learners must make mistakes, they must grow. Was there no any other alternative short of suspension that you might have considered in the circumstances, so that at least you don't limit their right to education? I'll tell you why I'm asking this, because imagine the things that they'll be exposed to if they're sent home. They spend the whole day in the streets, they may be exposed to drugs, they may be exposed to other things. So was there no any other alternative short of suspension that you might have used in circumstances to ensure discipline?
Well, my justice, the facts are unclear on the maximum period of the suspension, but we'll refer to the School Act, which states that the maximum period of the suspension is 7 days, meaning it's a week, meaning that the school might have suspended the learners for no more than a week. Therefore, suspension acts as one of the ways that they could have modified such behavior.
2 minutes left.
If it pleases, may it please the court, shall I continue? Suspension, my justices, does not take away the right to education, but only limits it for a short period of time as it is temporary. It teaches them to avoid such behavior in future and prepares them for the real world, which needs self-disciplined people. My justices, with this council...
But Council, I'm not satisfied with your response, because in paragraph 7, we are told that, the 6 owners of the cell phones are immediately suspended from the school for the rest of the year. Hence my concern earlier to say that, wasn't that, an affront to the right to basic education of the learners, an unjustified limitation, as the applicant argued, to say, was there no any other alternative short of suspending them for a year at least, because now that was going to expose them to drugs, to violence, and to all other things, and maybe even permanent dropout from school?
If it pleases the court, I would like my co-counsel to answer that question.
My justices, I understand your question is regarding the first suspension period that was stated in the facts. My justices, the reason we went, or the applicant sent us to court, was so we could justify, or so they could understand what it is that happened. This led to us validating or changing our suspension period, which was a maximum period, which in this case was stated in the South African Schools Act, which says, subject to this act and any applicable provincial law, the governing body of the school may, after a fair hearing, suspend a learner as a correctional measure for a period not longer than 1 week. The second suspension, my justices, was according to the South African Schools Act, for we did notice our mistake.
You can proceed, please. Thank you so much.
Time is up.
Thank you, counsels. On behalf of the respondent, you may hand over to your co-counsel to present their arguments.
My justices, as my co-counsel had stated before, my name is Boyebusisiwe, and I'll be dealing with the second submission of the respondent's argument. The SGP's decision to suspend the applicants does not violate their right to peaceful assembly, and it is therefore constitutional. This decision to suspend the applicants after the protest they displayed outside of the school premises is valid and constitutional. In this case,
The respondent's conduct cannot be considered as wrongful as the decision merely limited the applicant's right to peaceful assembly, for they infringed upon other learners' rights as well as public order, making it reasonable and justifiable in terms of Section 36, subsection 1 of the Constitution. For it was said in the case of the government case of South African Transport and Allied Workers Union, Satao and another versus Govers and others in paragraph 53 that, and I quote, "Nothing said, therefore, detracts from the requirement that the right in Section 17 of the Constitution must be exercised peacefully. And it is important to emphasize that it is the holders of the right who must assemble and demonstrate peacefully. It is only when they have no intention of acting peacefully that they lose their constitutional protection." The counsel for the respondent would like to submit to this oral report that the limitation to the applicant's right to assembly in terms of Section 17 of the Constitution is reasonable and justifiable for the following reasons based on the limitation clause as per Section 36 of the Constitution. Firstly, the nature of the right. The counsel acknowledges that the applicant's right to assembly, demonstrate, picket, and petition, it is a fundamental right, but it is not absolute. This means that it can be limited by Section 36 of the Constitution. Secondly, the importance of the purpose of the limitation. The limitation is enforced to maintain public order outside the school premises, as well as create a productive learning environment. The limitation is used to show that irrational behavior, which in this case is the learners' protest that infringed on the SGP's right to association in terms of Section 18 of the Constitution, as well as other learners' rights to basic education in terms of Section 29 of the Constitution, does not solve the problem, but instead makes the matter worse. The limitation prepares the applicants for the outside world, which demands critical and rational thinkers. Thirdly, nature and extent of the limitation. The applicant's right to freedom of assembly is limited in this case. Their right to protest, though spontaneous, causes major complications and therefore creates a reasonable and justifiable reason for limitation. Fourthly, my justices, the relation between the limitation and its purpose. The limitation serves to maintain public order, the protection of the rights and freedoms of others, which are the freedom of movement and the right to education, as well as to prevent community disruptions that had been caused by these learners' protests. Lastly, less restrictive means to achieve purpose. My justices, in this case, it is the second suspension. The applicant's right violated the rights and freedoms of others, and as a sanction has been imposed for this offense. The respondent's decision to extend suspension for the learners, therefore, is less restrictive than the actual limitation. My justices, the Code of Conduct acts as a beacon of preferred discipline at the school with the aim of modifying behavior to ensure better and noticeable results. The suspension of the learners due to the mismanagement of their right to assembly, demonstrate, picket, and petition serves as a lesson to other learners that irrational thinking has profound consequences. In light of the arguments advanced and authority cited, the respondent humbly pleads before this honorable court to, firstly, declare the High Court as correct. Secondly, to rule that the respondent's decision to suspend the applicants does not violate their right to education in terms of Section 29 of the Constitution. Thirdly, to rule that the school's code of conduct is constitutional. However, if the court should find it unconstitutional, the applicant must serve their secondary suspension period for their illegal protest. For this act of kindness, the respondent function shall be duty bound forever. My justices, if it pleases the court, the respondent would now like to take their leave.
Thank you, counsel, on behalf of the respondent. Do my learned colleagues perhaps have any questions to pose to the respondent, seeing as they do have a bit of time left over?
Nothing from my side, Presiding Judge, except that I didn't get their names, on the chat box.
All right. Respondents, if you could just address that. Justice Fletcher, any questions?
Nothing from my side.
All right, great. Thank you. So we'll hear from the applicant with their rebuttal then.
As it pleases the Court of Justice, that the points that were done by side respondent in this case must be declared invalid for the following reasons. So the justices, we submit that the expectation of a limitation of a right to privacy doesn't invite an unrestricted violation of the right in this case, your justices. So if means that the limitation that the respondents placed in this regard or in this case doesn't invite an unrestricted violation of the applicant's right to privacy as it pleases the court. So moving on, your justices, we are aware that the side respondent in this case are rather stating the school's interest too broadly. We therefore submit the KwaZulu-Natal versus Pillay case, paragraph 98, which states that both discipline and education are legitimate goals. However, care must be taken not to state the school's interest too broadly. We therefore submit and we therefore affirm that the school should, in fact, provide both education and discipline as their legitimate goals. But however, in this case, we must weigh the best interest of the child since it is dealing with children. And we therefore submit section 28 of the Constitution, subsection 2, which states that a child's best interest of paramount importance in every matter concerning the child. And the child's paramount interest in a school is of receiving education that we see that the respondents in today's case totally disregards. So the justices, our point of cohesion is the failure of the respondent to provide a less restrictive measure as Section 9 of the Schools Act envisions suspension as an extreme measure of discipline by providing that there must be a fair hearing where the learners can make representations. And we see that the school in this case, again, rather stated their interest too broadly by suspending the learners, furthermore, without a fair hearing. And we therefore submit to justices that the prohibition of learners from school premises was not aimed at promoting a positive discipline, but rather promote ill discipline, since we do not know what the outside world has for the students, since we see that the prohibition of learners will open a can of worms. If it pleases the Court of Justices, I would like to take my leave.
Thank you so much, Counsel, and thank you both for your submissions. I declare this court as being adjourned. Well done to both the teams. As I said earlier, making it this far really is a big deal and you should be proud of yourselves. I don't think we have much time because the justices do need to take a break before the next round. So I'll just ask that the justices add their comments to their score sheets and to send their score sheets as soon as possible to Joyce, Simon, and Philip. To the teams, well done, and that's it for this morning. You may leave the courtroom. For that, can I ask you to write in the chat box to everyone so that the justices have your names in their score sheets? So write your name, surname, speaker number, and the amount of time. Seeing as it's an ex parte round, I'm just going to allow you to write that down and then we'll get started after you've written it down. Justice Njovu,
Applicants.
are you in a position to do timekeeping for us?
I can do that, President Judge.
Thank
Justice
you.
Fletcher was doing it very well. I'm not so sure if she's still in. Maybe she can.
She's in, and I thought to relieve her of her duties, but of course, if she's willing.
I can carry on. It's not a problem.
All right, great.
Okay, thank you so much, Justice Fletcher. Yeah.
Thank you. All right, so once the teams have indicated their time allocations, Justice Fletcher, once you're ready with timekeeping, you can signal to start.
Okay, if the applicants are ready.
Yes.
Right?
Hi. Because I can see it right now. Hi.
Okay, we're just waiting for the applicants to type in their names for us.
OALA. Oh my freaking word. So.
Applicants, a reminder that your mic is on, so we are privy to your conversations.
Okay, I'm ready when the applicants are ready.
Your Justices, this matter concerns our young clients whose voices need to be heard. Our clients whose right to privacy, education, and peaceful assembly that have been violated. I will be speaking on the unconstitutional.
Sorry, applicants, maybe just to pause a bit and maybe on your time, Justice Fletcher. I see that team 115 are in our waiting room. I think they are lost. I'm not so sure how we can help them, President Judge. Can you see them? I think they're not supposed to be here. I'm not so sure. Maybe Joyce can
Unfortunately,
advise.
I don't have host or co-host privileges, so I cannot see them, but you can send them a message to let them know that they're in the wrong courtroom. Otherwise,
it is fine.
Yes.
Justice Nyamazi, we will deal with it with the technicians. Thank you.
Thank you. Thank you.
Okay, no problem. Thank you so much, Joy. Thanks. Yeah.
You may restart application.
Councils, you can. Yeah, you can restart. Okay.
Your Justices, this matter concerns our young clients whose voices need to be heard. Our clients whose right to privacy, education, and peaceful assembly that have been violated. I will be speaking on the unconstitutionality of Section 4 of the Njandula Combined Schools Code of Conduct. Its violation to our clients' rights to privacy in terms of Section 14 of the Constitution and its violation of our clients' right to education in terms of Section 29 of the Constitution. My co-counsel, Ms. Tony Makwala, will be speaking on the SGB's unconstitutional decision that violates our clients' right to assembly, demonstration, picket, and petition as stated in Section 17 of the Constitution. Your Justices, firstly dealing with Section 4 of the Njandula Combined Schools Code of Conduct, which states that the use of cell phones, whether on or off, by learners in school premises shall at all times be prohibited. Any learner that is found with a cell phone in possession shall have that phone confiscated and will be immediately suspended. We submit that this section in the school's code of conduct is unlawful
as it does not correlate with the guidelines for a governing body in adopting a code of conduct for learners in a public school, as given in Section 11 of the South African Schools Act, which states the offences that may lead to suspension. Some of the offences are fighting or battery, bullying or intimidation, conduct which endangers the safety of others and violates the right of others, harmful graffiti, sexism, or hate speech. Your justices, if you check this section properly, nowhere does it state that merely having a phone in your possession, not even in use, it may lead to suspension. Yet that is what our clients are faced with. A code of conduct of any South African school is supposed to correlate with the guidelines given in the South African Schools Act, thus then proving the unlawfulness of Section 4 of the Njomelo Combined Schools Code of Conduct. In the case of Anthony versus governing body of the Settlers High School 2002, paragraph 17 stated, and I quote, "The question should be asked in this regard whether or not prohibition is aimed at positive discipline and whether or not non-compliance therewith justifies punishment or some other form of sanction. This requires a spirit of mutual respect, reconciliation, and tolerance. We submit to this court that these cases are of similar nature because in both instances, the applicants were given a punishment not of the same standard as of the mistake made. The applicants received a punishment that could have been in less restrictive means. It did not fit the mistake that they had made. Suspension is way too big for merely bringing a phone to school. You're moving on to how then the school violates the learner's rights to privacy. The Njomelo Combined School searched six clients and other learners without reasonable cause. The school didn't follow the proper grounds for a search, as stated in Chapter 5, Section 8, Subsection 3, Article 2 to 4 of the South African Schools Act, which says that a random search may only be conducted when the safety or health of the learners in school is in question, where there's reasonable amount of evidence given of illegal activity happening, and or where the evidence is received. In our client's case with justices, none of this had taken place, yet the school still went on to conduct the search. The school continuing with the search meant it violating our client's right to privacy as stated in Section 14, subsections B and C of the Constitution, which state that everyone has the right to privacy. Yes.
Sorry, Councillor. Just a quick one. So are you saying that can the right to privacy be limited in any circumstances? You are submitting before us that the learners have the right to, to privacy, as provided for in Section 14. That's correct. But now my question to you is: are there any circumstances where we can limit the right to privacy?
Your Justice, the right to privacy can be limited, but under the circumstances that reasonable evidence of illegal activity taking place is given, or when the safety and health of learners in that school are in question, Your Justice. In our client's case, we didn't have any of this.
5 minutes left.
But seeing that, sorry, Councillor, follow-up question quickly. I'm off your time. Seeing that the school was chaotic and all that, how best then was the SGP and together with the school authorities going to maintain order?
Your Justice, we believe that they could have taken less restrictive ways of dealing with this. The less restrictive ways could have been them just confiscating the phone of learners on simply not allowing learners to use phones in class, as the disruptiveness was caused by learners using their cell phones in class, not having their cell phones in their possession, Your Justice.
Thank you. Proceed, Council, please.
violated our client's right to privacy as stated in Section 14, subsection B and C of the Constitution, which states that everyone has the right to privacy, which includes the right to not have their property searched or their possessions seized. They violated this right by searching our client's bags. The school failed to take these laws into consideration, but went on to suspend the learners without a hearing. Which brings me to my last matter, the violation of our client's right to education. Section 4 of the Njondolo Combined Schools Code of Conduct is also not in correlation with Section 9, subsection 1 of the South African Schools Act, which states that subject to this Act and any applicable provincial law, a governing body of a school may, only after a fair hearing, suspend a learner from attending the school, thus then allowing the school to infringe on our learners' rights to a fair hearing. As in their code of conduct, they state that learners may be suspended immediately for merely having a cell phone in their possession. The suspension of our clients for the rest of the year was a violation of their right to basic education in terms of Section 29 of the Constitution. This was because they didn't allow our clients to attend school, therefore blocking them from receiving any type of formal education. This, your justices, happened without a hearing, and they were suspended for more than 10 days, which is a clear violation of Section 9, subsection 1A of the South African Schools Act, which states that a learner may only be suspended for the maximum time, which is a week. Whereas in our client's case, your justices, they received suspension for the rest of the year. We believe that then this all goes to prove the unconstitutionality of Section 4 of the Njondolo Combined Schools Code of Conduct and how it is not implemented in the best interest of the learners, because there could have been less restrictive ways to deal with the cell phone problem in the school. We plead to the court then that this section in the school's code of conduct be reviewed and be checked to whether it is in alignment with the Constitution and the South African Schools Act, as those are primarily, yes, Your Justice.
Sorry, Counsel. Just to complicate your life a bit, but isn't it your client consented to the court? When the court was being drafted, the facts tell us expressly so and explicitly that, you consented after I consulted the process to draft this code. Now, you are saying to us that we must, find this code to be unconstitutional, the same code that you consented to. What is your comment on that?
Your Justice, the SGB and the learners of the school agreed to this section, with the meeting in the school. We believe that it is of their right to then, once they find that there's some unconstitutionality to this law, to then appeal to the court again that they do not agree with the section of the Code of Conduct.
Thank you so much. You can proceed, please.
We plead to the court that this section be checked as to whether it is in alignment with our Constitution and the South African Schools Act, because these are the laws and regulations that any school in South Africa is supposed to follow. Thank you.
Tom.
Thank you so much for speaking on behalf of the applicant. We'll hear from your co-counsel.
If I may, Your Honorable Justices, I have two submissions to make in continuation of what my co-counsel has already said for the applicant's case. A submission deals with the STB's decision to continue with our client's suspension and how that decision has violated our clients to peacefully and unarmed to assemble, to demonstrate, to picket, and to present petition, being Section 17 of the Constitution. My first submission deals with the decision that both the SGB and its principal decided to take when they decided to suspend our clients with no fair hearing, and also what the suspension of this unconstitutional and unlawful act was upon. Chapter 2, Section 9, Subsection 1 of the South African Schools Act states, the governing body of a public school may only, after a fair hearing, suspend a learner from attending school. It carries on to 1A and says, as a correctional measure of no longer than a week. The justices, our clients were suspended with no fair hearing and were also suspended for the maximum period. This decision is a pure encroachment on the South African Schools Act, nor is it in accordance with the law. The principal of the school first suspended our clients with no fair hearing or any interference from the SGB. Our clients fought this injustice, and when the SGB interfered, they took the principal's decision without even hearing our clients out. Secondly, we submit that Section 17 of the Constitution has been violated on a number of reasons. Firstly, the SGB called a meeting to decide on what to do with our clients protesting. And without our clients' presence, they decided to suspend them for the maximum period. When our clients were protesting, they did so in the hopes of that it get the fair trial or the fair hearing that Sisotele received, and also in the hopes that this time proper protocol would be followed. However, the SGB retaliated by infringing more and more of the law. The justices, our clients convened because of the unconstitutionality that had been brought upon them. They gathered to get the attention of the respondents. All they wanted was to be heard, and having used the right of peaceful assembly means that the voiceless are given some sort of power to fight their oppressors. However, this right has
a question. Would you not say that in light of the prevailing circumstances, the suspensions were reasonable and justifiable, notwithstanding the fact that the violence may or may not, or rather the damage to the property may or may not have been caused by the particular learner suspended, but having knowledge of the fact of their involvement in, for example, the first gathering, albeit that it was spontaneous, would you not say that the suspensions were reasonable and justifiable?
No, Your Justice, because Chapter 2, Section 9, Subsection 1 of the South African Schools Act states that a learner may be only suspended after a fair hearing, and this, Your Justices, was something that the respondents did not do. So no, Your Justice, the suspension was not at all right.
Thank you, Counsel. Please proceed.
All they wanted was to be heard, and having used the right of peacefully and unarmed to assemble from the Constitution means that the voiceless are given some sort of power to fight their oppressors. However, this right has been limited unjustifiably by the Regulations Gatherings Act, Chapter 1, Section 3, that states that a notice of gatherings must be given to the responsible officers in no less than 7 days. We believe that the right being Section 17 of the Constitution has been limited unjustifiably because when our clients convened, they did so because they did so in the hopes of that they wanted to express their frustration due to the injustices that had been brought upon them that day. And having to give notice would have delayed the protest or our clients attending to the problem of the matter at hand. It would have shifted their attention from the protest to having to give notice, and it also would have made them lose enthusiasm and the need for the protest to happen as well.
Sorry, Counsel. Another question. Just as you argue that your clients had a right to be heard, would you not say that reasonable notice should have been afforded to the school in the interest of fairness, just as you say your clients were treated unfairly in that they were not given an opportunity to be heard? So the school would rightly say that we too should have been afforded an opportunity to at least be addressed on the concerns and be notified of any possible protest action. What's your
5
response to
minutes.
this?
5 minutes left.
The justice. Our clients having to give notice would then have delayed our clients having to deal with the matter at hand, and it also would have made them lose enthusiasm and the need for the protest to happen as well, due to the fact that before giving a notice, they have to give a notice 7 days before the protest to happen. This then means that they would have had to wait until the 7 days was finished for them to continue with the protesting. If I may, the SGB's decision restricts pupils from hosting peaceful assembly because the students will face retributive consequences, thus cornering them to waiver this right. When it comes to the case of Nungwan and others versus S and another, paragraph 43 says, Section 17 guarantees the right to assemble peacefully and unarmed. The content and scope of this right must be interpreted generously. However, its meaning is clear and unambiguous. Everyone has the right to assemble, demonstrate, picket, and present petitions, but the only internal qualifier is that anyone that decides to practice this right must do so peacefully and unarmed. We submit that our clients were indeed protesting peacefully and unarmed. These two cases are of similar nature, as both cases were and are still fighting to continue expressing themselves through protesting. We as counsel for the applicants acknowledge and respect the right being Section 17 of the Constitution, and we see it as an important right regarding the history of South Africa. The SGB's decision was indeed unconstitutional because our clients were not violent, were unarmed, and nor did they bring any harm to people. When we consider the Garvers case, paragraph 52 says, everyone who is unarmed has the right to go out and assemble with others to demonstrate, to picket, and to present petitions to others for any lawful purpose. The wording is generous. It would need some compelling context to interpret this provision as actually meaning less than the wording promises. This inherent power and value of freedom of assembly and demonstration is as a tool of democracy, often used by people who do not necessarily have other means of making their democratic rights count. Both these historical considerations emphasize the importance of this right. Again, no justices, our clients were just voicing out their grievances, and their protesting was a way of them taking out their frustrations peacefully and with the hopes of that they'd be heard. All of this, your justices, should give enough proof on how unconstitutional the SGB's decision was and how it violated our clients' right to peaceful assembly in terms of Section 17 of the Constitution. Our clients were just voicing out their grievances, and we believe that the SGB's decision to continue with the suspension was unlawful on those grounds. We plead to the court to find the SGB's decision as unconstitutional and that it violates the learner's right to peaceful assembly in terms of Section 17 of the Constitution. With that being said, I'd like to conclude my argument. Thank you.
Thank you, counsels. And because this is an ex parte round, that does bring us to the conclusion of the proceedings. A very well done to the both of you. Congratulations for getting this far in the competition. I'm not sure if we have time for the next round of comments. It seems as though maybe the next set of participants are already in the waiting room. I'm not sure what everyone else's schedule reflects, but I do believe that this session still has time. Can someone just confirm this?
Indeed, it is confirmed this session is scheduled to end at 11:10. So ample time.
Okay, so maybe we can just briefly give them some constructive feedback, nothing really on the substantive matter of the case. just general feedback for them to work on or to encourage them or to affirm what they did. We can start with Justice Fletcher.
I think both ladies spoke really well and concisely, and they definitely knew the case law, and they knew their clients, so to speak. Maybe just a little bit slower, but I thought they did really, really, really well, and well done.
Thank you so much, Justice Fletcher. Maybe we can go to Justice Pule next.
Good morning again to both contestants. Very well done to you both. You were clear, you were confident, you paced yourself well. You had good argumentation and good knowledge of the facts and good application of the law to the facts. So keep it up as you progress through the rounds. All the best. And yeah, just guard against being complacent. I'm sure now you're well versed with what you need to know, but keep up the good work. Don't slack and just keep going on, and all the best. Thank you.
Thank you so much, Justice Pule. Justice Ndlovu.
Thank you so much, Presiding Judge. I don't have anything except to say that all the best for the future. Should you go through to the next round, maintain the confidence, like you were told in the first day, that you are all winners. And yeah, you will make good lawyers one day should you choose to be in the profession. All the best.
Thank you so much. And last but not least, Justice Khomosotho.
Thanks, Chief Justice. Just a few comments from my side. I was very impressed with this team, particularly because I heard them before and I noted the improvement based on the comments we made them. So congratulations on actioning those. I thought it went much better than the last round that I heard from you guys. And I mean, I can take the liberty to say this because, you know, we don't have an opposing team. I thought, you know, the applicant is really your strongest side. I was very impressed with, you know, how thorough your preparation was, your knowledge of the facts of the law. Very impressive standard of presentation as well. It's very high level. Again, I can tell you guys did a lot of work and preparation going into this. And just one thing that struck me as you guys were speaking was the fact that in the previous round you guys were arguing respondent and making very compelling arguments there as well, and you know, making, you know, equally if not more compelling arguments here for the applicant. And you know, for me, that's one of the great things about this experience of moot, is that, you know, it really teaches you to assess problems from both sides, and you guys have demonstrated that very well. You know, so well done on that. I found your presentation to be, you know, very well thought out, very strategic. So yeah, congratulations. Fingers crossed.
Thank you.
Yes, thank you so much. I think I echo all my learned colleagues' comments, especially that we are genuinely impressed. We don't say it because it's supposed to be said. We say it genuinely because we mean it. So congratulations to the both of you. We do hope to see you in the future rounds, but if not, please do not despair. It's not a reflection of the quality of work that you have presented before us. Be assured that we are well impressed. Outside of any administrative questions or clarifications, I think that's it for this round. So the teams are welcome to leave the courtroom. And then the justices, if you are staying in this court, you're welcome to stay. And if not, you're welcome to leave. And please be reminded to send your score sheets to Joyce, Simon, and Philip as soon as possible.
Okay, off you go, ladies.
My justices, may it please the court. I am Boyusi and together with my co-counsel Mulumedi Anisa, we appear before this honorable court on behalf of the applicant. I'll be speaking for 11 minutes and my co-counsel will speak for 7 minutes, and we will reserve 2 minutes for rebuttal. We intend to present to this honorable court 2 submissions with a third submission in which I'll present the first and my co-counsel the third, and I'll present with a second alternative submission. Our submissions before this honorable court are as follows. The applicant submit that Section 4 of the school's code of conduct is unconstitutional and it violates the applicant's right to privacy and basic education in terms of Section 14 and Section 29 of the Constitution, respectively. Alternatively, the applicant submit that the school's code of conduct should be struck out as it is not a rule of general application and it is applied arbitrarily by the school. Furthermore, the applicant submit that the SGB's decision to suspend the applicants is unconstitutional as it violates their right to peaceful assembly in terms of Section 17 of the Constitution. My justices, our first submission regarding the constitutionality of Section 4 of the school's code of conduct in relation to the infringement of the applicant's right to privacy and basic education. Section 4 of the school's code of conduct states, and I quote, "The use of cell phones, whether on or off on school premises, shall at all times be prohibited. Any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended." Section 4 of the school's code of conduct essentially grants the school power to search the bags of all learners at random and without notice to such learners. The effect of this rule is that it infringes upon the learner's right to privacy, a right granted by Section 14 of the South African Schools Act of the South African Constitution of the Bill of Rights. Section 14 of the Constitution states that, and I quote, "Everyone has the right to privacy, which includes the right not to have their person or home searched, their property searched, their possessions searched, or the privacy of their communications infringed." And we submit that the search conducted by the school and the confiscation of the learner's cell phones is a violation to this right. Privacy becomes more intense the closer it moves to the intimate personal sphere of the life of human beings. Cell phones have increasingly become more central to human lives. They contain apps that have our personal information or sensitive information, personal texts, apps that track our fertility and other sexual reproductive details. Losing a cell phone, or worse, having it confiscated, takes away the owner's access to all of this. It takes away from the owner's autonomy and arguably their dignity as well, a value granted to everyone by Section 10 of our Constitution. A rule such as this one that infringes upon autonomy, dignity, and right to privacy is surely unconstitutional. My justices would like to remind us all.
Sorry, Counsel, just a quick one. But again, I'm going to pose this question, which I think keeps coming to my mind, to say Section 4 of the code came about after a consultative process between yourself or your clients and the SGB. Now, and you want us to, to declare this section unconstitutional. Do you want to comment on that, perhaps? Because you consented to the court, and now you are before the court. You are saying that it is an affront to your right previously in Section 14. Maybe if you can help the court to understand this dilemma here.
My justices, when Section 4 of the School's Code of Conduct was implemented, it was based upon the regulation of the use of cell phones in the school. In this case, they had not taken into consideration what would happen to lead to the infringement of the learner's right to certain rights, which are privacy and basic education and the children's interest. Therefore, before then, it was not proved to be unconstitutional because it was more focused on the aim of the regulation of the use of cell phones in school.
You can proceed, Counsel. Thank you.
My justices, a child's best interest of paramount importance in every matter concerning the child. And subsection 3 states that in this section, child refers to a person under the age of 18 years old. And the applicants are all below the age of 18.
Not only did the school violate this children's right to privacy in terms of Section 14 of the Constitution, but they went as far as to violate their right to basic education in terms of Section 29, subsection 1, paragraph A of the Constitution, which states that everyone has the right to a basic education, including adult basic education. My justices, we saw how when the learners, the applicants, were found in possession of a cell phone, they were immediately suspended for the rest of the year. This goes against Section 9, subsection 1, paragraph A of the South African Schools Act, which states that, and I quote, subject to this act and any applicable provincial law, the governing body of a school may, after a fair hearing, suspend a learner as a correctional measure for a period not longer than 1 week. My justices, the suspension is extreme and the limitation is unreasonable and not justifiable, for the school ought to follow the South African Schools Act and make sure that they are not violating the rights in the Constitution. Moving to our second.
Council, sorry, before you go on, when I read Section 4 of the Code of Conduct,
5 minutes left.
I don't read Section 4 to say that the students may be searched. When I read Section 4, it just says any learner that is found in possession of a cell phone shall have that phone confiscated. So is there not a way that we can, as the justices, as the court, can read that clause and say, if the student's walking through the school with a cell phone, then that school can be confiscated, that phone can be confiscated. But that the Code of Conduct is constitutional, but that the searches were unlawful. Is there not a way that we can read that?
My justices, please rephrase your question.
So are you saying that the Code of Conduct is unconstitutional, or just that the search was unconstitutional? Because I read the Code of Conduct to not deal with any searches. It just deals with having the cell phone at school.
My justices, I refer this court to Section 2 of concerning the supremacy of the Constitution, which states that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. My justices, this infringement upon the learner's right to privacy, which is in relation to their dignity, is an infringement, and it does not coincide with the provision of the Bill of Rights. Therefore, the procedure in relation with also Section 4 of the Schools Code of Conduct makes it unconstitutional.
Thank you.
If it pleases the court, we'll now like to move to the second submission of the applicant's argument about the rule of general application. The rights granted in the Bill of Rights are, of course, not absolute. They are limited by Section 36 of the Constitution, otherwise known as the limitation clause, which states that the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. Being that the school sees the cell phones following a rule, and it being true that all the rights in the Bill of Rights are limited, it is also true that the rule that limits the rights should be that of a general application. When the code was first applied, the school ordered a disciplinary hearing to take place following the discovery of the cell phone of Sfiso Cele, which resulted in the suspension of the learner. With the applicant, however, no such hearing was held before they were summarily suspended for the remainder of the school year. The rule was in this way not applied generally. The question should be asked whether the limitation of the right to privacy by the school's code of conduct passes the limitation clause. Firstly, the nature of the right. The nature of the right that is being limited is a right that is directly linked to dignity and autonomy. Secondly, the importance of the purpose of the limitation. The purpose of the limitation, the right to privacy, is to enforce discipline in the school. Thirdly, nature and extent of the limitation. The limitation is one that takes away from the autonomy and the dignity of the learners, as their cell phones that contain personal and sensitive information are taken that way. Their ability to communicate, make financial transactions, plan their day-to-day lives is taken away. The limitation therefore cripples their modern-day lives. Relation between the limitation and its purpose. My justices, the aim of this rule is to enforce discipline and maintain or improve the school's results. Although the results have improved, there is no direct correlation between lack of privacy and improved marks. Learners who would choose to bring their cell phones and instead keep them in their bags would still be able to focus in class, but instead, however, other learners who keep their cell phones at home may still choose not to listen in class. Lastly, are the less restrictive means to achieve purpose? Yes, my justices. Instead, the school could put in place measures to have compulsory morning and afternoon studies. They could impose fines on learners who use cell phones during class. The Western Cape High Court in Anthony versus Governing Bodies at Ross High School, the question was asked in this regard, held that the question should be asked in this regard whether the prohibition is aimed at promoting positive discipline and whether or not non-compliance therewith justifies punishment or some other form of sanction. This requires a spirit of mutual respect, reconciliation, and tolerance. The mutual respect, in turn, must be directed at understanding and protecting rather than rejecting and infringing the inherent dignity of the offender. It is apparent that the confiscation of the cell phones in this manner rejects and infringes on the applicant's inherent dignity, and therefore the rule for my justices, I'll now hand over to my co-counsel who will be dealing with the second submission. State Section 36 is the rule.
I would like to move on to the third submission. The learners' rights to peaceful assembly, which was violated by the school governing body's decision to suspend the learners. Our final submission is that the school governing body's decision to suspend the learners is unconstitutional as it violated their right in terms of Section 17 of the Constitution, the right to peaceful assembly. My justices, Section 17 of the Constitution states, and I quote, "Everyone has the right peacefully and unarmed to assemble, to demonstrate, to picket, and to present petitions." Ours is a country that is riddled with a history of inequality, where only a select few were entitled to voice out their concerns and petitions. We are a country with a history of protest action, as this was the only way that the Black population could raise their concerns and be heard. My justices, it was said in the South African Transport and Allied Workers and Another versus Govers and Another in paragraph 61 that the right to freedom of assembly is central to our constitutional democracy. It exists primarily to give a voice to the powerless. This includes groups that do not have economic or political power or other vulnerable groups. It provides an outlet for them to express their frustrations. This right will, in many cases, be the only mechanism available for them to express their legitimate concerns. Children, your justices, are a minority and thus should be treated as so. Protest action is a tool for the marginalized and most vulnerable in our society to petition their pleas. My justices, it is important to note that in all matters concerning the care, protection, and well-being of a child, the standard that the best interest of a child of paramount importance must be applied. This is an important standard set by Legislation 9 of the Children's Act. School codes of conduct and decisions should adhere to the best interests of the learners who are still children and are very vulnerable members of our society. My justices, children are a group that is most vulnerable in our society. Not only do they face abuse in households, but they also face abuse in the public sphere and more increasingly in schools. Therefore, their rights should be protected. Protest action instituted by a vulnerable group in our society should receive more protection.
Counsel, are you equating the taking away of one's cell phone to abuse?
The limiting of the right to protest is, in this case, abuse.
Counsel, do you realize that the things that you're trying to compare to each other are drastically different? And by so doing, you bring down actual cases of abuse. Is that not inaccurate on your part?
Abuse would refer to abuse being that the rights of young children are often infringed upon as viewing them as members who do not have any other choice but to listen to authority.
So are you saying that any infringement of rights is abuse?
Infringements of rights that, yes.
even though the Constitution allows infringement of rights?
The Constitution does not allow infringement of rights. Rather, it allows for the limitation of rights.
Would that not be a form of infringement?
No, it would not, My Justice.
So a limitation and an infringement, even though they have the same outcome, they're not the same thing?
No.
All right, thank you.
Protest action is situated by members of a vulnerable group in our society should receive more protection. Punishment for such action by a body that purports to protect children, such as a school, is shameful and is unconstitutional. Protest action that is done on legitimate grounds, such as the violation of rights and protocols are protected by the Constitution. Any act that punishes children for exercising their right, therefore acts unconstitutional. We would like to end our argument against the respondent.
Sorry, Counsel. But how about their behavior when during protest action, disturbing public peace, and putting dustbins on the road, etc.? Should that conduct be condoned? What is your comment on that? Maybe will you address that aspect?
My Justice, it was said in the United Nations International Covenant on Civil and Political Rights, Article 21, as the European Court of Human Rights noted, an individual does not cease to enjoy their right to peaceful assembly as a result of sporadic violence or other punishable acts committed by others in the course of the demonstration, if the individual in question remains peaceful in his or her own intention or behavior. My Justice, the other applicants had no intentions to promote violence. It was just sporadic violence that happened without the intentions of the other learners.
Proceed, Counsel. Thank you.
We end our argument against the respondent by referring this court to Section 7 of the Constitution, and it states, "The Bill of Rights is the cornerstone of our democracy in South Africa. It enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. The state must protect, respect, promote, as well as fulfill the rights in the Bill of Rights." In light of the above arguments, applicant prays the above honorable court find in the favor of the applicant and grant an order confirming that Section 4 of the Code of Conduct is unconstitutional and violates the right to privacy, basic education in terms of Section 14 and 29 of the Constitution of South Africa. Alternatively, the code should be struck out as it is not in a role of general application and is applied arbitrarily by the school. Grant an order confirming that the SGB's decision to suspend the learners is unconstitutional as it violates the learners' right to peaceful assembly in terms of Section 17 of the Constitution. My Justices, if there are no further questions, Counsel on behalf of the respondent would like to take its leave.
Thank you so much, Counsel, for the applicants. I'm not so sure if there's anything from my co-justices. Anything or any question? If nothing, we'll then respondents, you can make your submissions, please. Thank you so much.
As the court pleases, I am Pili Lenene and I'm here with my co-counsel Tutu Wandlela. We are team 115 and we appear on behalf of the respondent. I'll be dealing with the first part of our argument, which is based on Section 24 of the Constitution of the Republic of South Africa and also Section 29 of the Constitution and also Section 36 of the Constitution of the Republic of South Africa, which is limitation of rights. And my co-counsel will be dealing with the second part of our argument, which is based on the unlawful protest that the learners formed in terms of Section 3 of the Regulations of Gatherings Act, number 205 of 1993, and also Section 4 of the School Code of Conduct, which deals with prohibition of cell phones at school.
In this case, there are 6 learners who went against Section 4 of the School Code of Conduct, and they were all suspended. They then decided to challenge the school governing body's decision in high court, arguing that their suspensions were unconstitutional as they were merely exercising their rights of peaceful assembly. The court ruled in favor of the respondent. The question, after their leave to appeal was refused in the Supreme Court of Appeal, they then decided to appeal the decision of the High Court in this court. The question before the court is whether Section 4 of the School Code of Conduct is unconstitutional and violates the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution of the Republic of South Africa, 1996. The counsel for the respondent therefore argues that Section 4 of the School Code of Conduct is not unconstitutional and does not violate the learner's right to privacy and basic education. And also that the school governing body's decision is not unconstitutional and does not violate the learner's right to peaceful assembly, demonstration, picket, and petition in terms of Section 17 of the Constitution of the Republic of South Africa. Section 36 of the Constitution is the limitation of rights. As much as the learners had the right to express their feelings to basic education in terms of Section 16 and 29 respectively of the Constitution, their protest was joined approximately by 100 learners, and that disrupted the process of teaching and learning, which could lead to a decreased school pass rate, as it is clear that the school sought to improve the pass rate. And also, if we look at the case of Anthony versus governing body, such as high school, in 2002, paragraph 17, it is said that the question should be asked in this regard: whether or not the prohibition is aimed at promoting positive discipline and whether or not non-compliance justifies punishment or some other form of sanction. This requires a spirit of mutual respect. And that mutual respect may mean that the learners must abide by the school rules for the better discipline and more purposeful school environment. And this further supports the constitutionality of Section 4 of the School Code of Conduct, as it was also aimed at promoting positive discipline. As Section 36 clearly puts it, that
Sorry, Council.
Yes, my Justice.
But don't you think that Section 4 is a bit arbitrary in the sense that it limits, I mean, in its entirety, even the possession of a cell phone, not the use, but how about in instances where the learner wants to get hold of their parents or their guardian, or on anything that may be, maybe they want medication or anything really. And now, especially that we live in the era of the 4IR, wherein we embrace the use of gadgets, especially by the younger generation, etc. Is it not a good thing to have a cell phone or even an iPad or even a laptop at school? What's your comment on that?
Thank you for the question, my Justice. My Justice, if the learners had brought cell phones to school for safety reasons, and also if they wanted to inform their parents about their whereabouts, they should have informed a teacher or an RCL member or the principal of the school that they had brought cell phones to school for various reasons.
Thank you so much. Proceed, please.
Thank you, my Justice. As Section 36, subsection 1 clearly puts it, that the right in the Bill of Rights may only be limited in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors. So the school also had to limit the learners' rights, hence why they called the police when the learners were protesting, because when protesting, the learners violated the other learners' rights. The learners that were not protesting, their rights were being violated. Since the learners were suspended, they then decided to protest.
Section 24 of the Constitution of the Republic of South Africa is environment, and its paragraph A states that everyone has the right to an environment that is not harmful to their health or well-being, and its paragraph B states that everyone has the right to have a protected environment for the benefit of present and future generations through reasonable legislative and other measures that could prevent pollution and ecological degradation. And also Section 29 of the Constitution. And also Section 29 of the Constitution of the Republic of South Africa is education. It states that everyone has the right to receive education in the official language or languages of their own choice at a public educational institution where that education is reasonably practicable. So as soon as the learners started burning the dustbins, they made the environment unsafe for everyone that was there, because there was a possibility of fire escalating and burning the teachers' cars and also harming anyone that was there. And if that fire did escalate, it would have disrupted the process of teaching and learning, also affecting the learners who were not protesting, not only affecting them, but also violating their right to basic education, since they cannot study or receive lessons in an unsafe environment. The learners did not. Yes, my Justice.
Your point is quite valid and quite convincing, but there's no proof that the learners in question, especially those that are on trial right now, the 6 applicants, are the ones who started that fire. Is it reasonable for this court to just work on assumptions that they started the fire and then apply your reasoning, which I do agree with it? There was a violation, but it's not proven that the violation was rooted by the 6 applicants in question.
My Justice, please rephrase your question.
Who was responsible for the fire that you are discussing? Was it the 6 applicants on trial?
My Justice, if we look at Section 11, subsection 1 of the Regulation of Gatherings Act, it is stated that the conveners of a gathering are all liable for anything that happens during the protest, unless there is proof that proves that those learners are the ones who are not responsible for the fire.
All right, thank you. You may continue.
Thank you, my Justice, for the question. The learners did not only end there, but also violated the rights of others in terms of Section 21, which is freedom of movement and residence, subsection 1, which stipulates that everyone has the right to freedom of movement. The learners, when protesting, blocked the road, making it unavailable for the learners to pass so that they can reach school, and also employees not being able to get to work, and also an emergency. If someone in a crucial condition or state had to be rushed to hospital, they couldn't because of the blocked road. So the learners, when blocking the road, they made it unavailable for other learners to fulfill their dreams, because there are other learners who wanted to go to school and not be part of the protest. So them, by blocking the road, those learners could not reach to school, and they could not get on or continue with the process of teaching and learning. Also, the school code of conduct, my Justices, was aimed at establishing a purposeful and more disciplined environment. My Justices, as the respondent, we submit that we justifiable in limiting the right of the applicant, as this was for their own safety, because on their way to school, they could get mugged and get hurt, and also to protect them from cyberbullying. My Justices.
Counsel,
Yes,
could your client have done something else? Could they have suspended them for a shorter period, for example? Would that not have been better than suspending them for the whole year?
My Justice, thank you for the question. Yes, the school did realize that they had made some mistakes in punishing the learners. Hence why Ms. Koza After realizing that they made mistakes, she called a meeting saying that they were willing to rectify their mistakes, and they then suspended the learners for a maximum period, which is 1 week.
Thank you, Council.
Thank you, Justice. So as the respondent, we submit that we're justifiable in limiting the rights of the learners as it was for their own benefits. If there are no further questions, my justices, I would like to hand over to my co-counsel, who will be dealing with the second part of our argument.
As it pleases the courts, I am Dutu Ondlela, co-counsel of Pilinene, and I'll be dealing with the second part of our argument, which is firstly the unlawful process of the children, and secondly, I will be dealing with section 4 of which is the school code of conduct. So, Your Justice, firstly, after the learners were evicted from the school premises, they decided to protest outside the school gate. Now, the learners, they didn't issue out a notice to the school that they were going to protest. Now, if we look at section 3 of the Regulation of Gatherings Act 205 of 1993, its subsection 1 states that a convener of a gathering shall give a notice signed by him of the intended gathering in accordance with the provisions of this section. So it means that as the learners were protesting, their protest was the same as committing a criminal offense, because now they didn't issue out a notice. And if we look at section 12 of the Regulation of Gatherings Act, its paragraph A states that any person who convenes a gathering in respect of which no notice was given shall be charged on a criminal offense. Also, if we look at the case of Mlungwane and others versus another in 2019, which was ruled in the Constitutional Court, in paragraph 16 states that if a gathering proceeds without a formal notice, then section 12, subsection 1, paragraph A provides that it is a criminal offense to convene a gathering in which no notice was given as prescribed in this act. Also, Your Justices, if we look at section 1, paragraph A of the Regulation of Gatherings Act, it defines demonstration as any demonstration of more than 1 people, but not more than 15 people. And if also we look at the second strike, the protest that the learners held, and the third protest that the learners held, the second one was joined by approximately 40 learners, and the third one was joined approximately by 100 learners, thus making those 2 protests unlawful. Also, Your Justices, moving on to my other issue. The 6 learners brought the cell phone to school, going against section 4 of the school code of conduct, which clearly states that the use of cell phones, whether on or off by learners on school premises, shall at all times be prohibited. Now, any learner that is found in possession of a cell phone shall have their cell phone confiscated and may be suspended. Now, if we look at section 8 of the South African Schools Act, it states that it is the code of conduct. It states that a code must be aimed at establishing a well-disciplined and more purposeful school environment. Now, as the governing, it is the duty of the school governing body to draft a code of conduct, which is aimed at establishing or to maintaining a disciplined and purposeful school environment. Now, as the code of conduct of the school drafted this code of conduct, their aim was to establish a more purposeful and more disciplined school environment, as the principal had made rules before that had resulted in an increase in the pass rate for up to 72%. Now, also, Your Justices, as the learners, as they brought their cell phone to school, they were fully aware that there was a possibility that their cell phones could get confiscated and that they may be suspended for that action. Also, Your Justices, if we look at the case of South African Transport and Allied Workers Union and another versus Govers and others in 2013, which was ruled in the Constitutional Court, in paragraph 53 says that nothing said thus far detracts from the requirement that the right in section 17, which is assembly, demonstration, pickets, and petition, must be exercised peacefully. And it is also important and it is also important to emphasize that it is the holders of the right who must demonstrate and assemble peacefully. And it is only when they have no intention of acting peacefully that they lose their constitutional protection. Now, your justices, the learners' protest was no longer lawful since there was a burning of the dustbins and there was a blockage of the road. So, your justice, thus making their protest less lawful and making their concerns now less legitimate. So, your justices, with that said, in summary for our argument, we as the counsel for the respondent, we have shown that Section 4 of the School Code of Conduct is constitutional and it does not violate the learner's rights in terms of Section 14 and 39 of the Constitution, since it was only aimed at maintaining a more disciplined and purposeful school environment. Now, your justice, we as the counsel for the respondent, we therefore humbly request this honorable court to firstly declare that the High Court was correct in finding that there was no violation of the learner's rights in terms of Section 14 and 29 of the Constitution, which is privacy and basic education. And to secondly, to rule that the SGP's decision does not violate the learner's rights in terms of Section 17, which is assembly, demonstration, picket, and petition, since the learners did not give a notice for their protest. Now, your justices, these are submissions before this court. If there are no further questions, your justices.
Thank you so much, counsels, for the respondent. I'm not so sure if there's any question from my co-judges. If there's nothing from my co-judges, thank you so much, counsels, for those excellent submissions. I will then ask the applicants to.
My justices, if it pleases the court. Firstly, counsel for respondent stated Section 3, subsection 1 of the Gatherings Act, which refers to a notice being needed. But my justices, a notice is needed when those protesting are more than 15, but we only have 6 learners as the applicants who protested upon the unfairness of the situation and the suspension with no fair hearing. Secondly, the respondent mentioned Section 36, and it clearly informs us that a rule that limits is that of a law of general application. And this code of conduct is not applied generally as proved before, which therefore informs us that it cannot limit this learner's right to privacy and basic education.
Sorry, counsel, you are muted.
Yes, my justices. With that, we have applied our rebuttal.
Thank you so much, counsels, for those rebuttals. Any comment from the co-justices? Justice Thomas, Justice Fletcher, Justice Martin? If there's nothing in relation to the submissions, thank you so much all for excellent submissions before this court. I'm particularly impressed by your improved submissions, both the applicants and the respondents. I wish you all the best for the upcoming rounds. And I think we're still doing well on time. Just a minute each to my core judges, just to give feedback. Just quickly, 1 minute each, please. I'll start with Justice Fletcher.
I want to say congratulations to both teams. Very well presented and very persuasive on your presentations. I think the future of our country, if you follow law, is looking good. And I wish you all the best going forward. It's exciting to see young people taking part in these kind of competitions and doing so well. It really gives me hope for this country.
Thank you so much. Justice Martin?
I absolutely agree with my learned sister. I'm so impressed. It's amazing to see young people grasping and putting together the links that need to be put together. And I encourage you to continue on this path of thought, even if you don't pursue the law. If you keep the skills of critical thinking, you will succeed in whatever field that you set your heart for. But congratulations and well done.
Justice Thomas?
Thank you, Justice Ndlovu. Yeah, congratulations, guys. Just want to really encourage you. I myself was part of these sort of moot competitions when I was in school, and it really set me up for my legal career. And it's, yeah, so just continue to pursue it. It was refreshing. You guys looked at some of the different sections, you focused on different areas, and you presented a very well-rounded argument. I thought some of the other situations that arguments I've sat in on, they've not looked as expansively as you have at different sections, at focusing on sections like section 36. That was really good to see. Well done.
Thank you so much, co-judges. Maybe, and lastly, from my side, I want to say, colleagues, I'm impressed with your submissions. I do train moot students here at the university where I'm based. If I had power, I was going to encourage you to come study law here. But anyway, like it was said that this country and this continent is one of some of the brightest minds I think in the world. Really, you leave this place with knowledge that general people will not have, and I hope that you impart that to your family, to your colleagues at school, to your mates, about the protection and the importance of human rights, especially for learners and for young persons. I specialize in children's rights, and seeing some of your compelling arguments that you put forward to protect, to promote, and to ensure the respect of the rights of children, really, I can't express how happy I am. Thank you so much, colleagues, and should you go forward, all the best. And if not, you are still a winner and you are excused from this court. Thank you so much. All right. To my co-judges, I think we're done for the day. I'm not so sure if we still have a session that's upcoming.
I think there are sessions, but I'm not going to be part of them. So it was lovely being a co-judge with everybody, and I wish you all a lovely weekend, and hopefully we can all meet again like this next year.
Yeah.
Yeah, I echo
thank you so much, Justice Fletcher. And yeah, all the best. We hope to meet in future. And I think Justice Marty still has 2 more sessions. I'm done also for the day. Yeah.
I'm still in the chair.
Enjoy. It's a privilege. I think it's a privilege. It
really
makes
is.
me excited to see these young people and hear, and I think mainly nerves take over sometimes, but they wouldn't be there if they really didn't want to follow this path, and I'm excited.
Very true. All right.
Yeah, I agree fully. Yeah. All right,
Okay,
Mati, we're going to
everybody.
leave you here, my learned colleague. We're going to leave you here, and we are off.
Thank you, guys. Cheers.
Okay. Keep well, everybody.
Webcast support. I'll be back in time for 12:30, I believe, is when the next round starts. few delays and hiccups along the way, but regardless, we are now all here and we'll be able to get started. So let's get right into it. You're not new to this game now by this stage, and congratulations for proceeding to the next phase. You should be very proud of yourselves. It's a great show of your efforts and what you've acquired and the knowledge you've acquired throughout the competition. So a reminder to the teams to put their names and times in the chat box so that the justices have them in their score sheets correctly. Justice Bum, are you able to time keep for us?
With pleasure.
Okay, great. Applicants, what is the time division between the two of you?
I'm writing it in the chat box.
Okay, I see that the first speaker, I'm assuming, is Council Mangai, is speaking for 10 minutes. So we'll be able to start with them. So Justice Bum, whilst you're ready, you can give the team, the applicant team, the go-ahead to start.
Just to clarify, for the applicant team, you have first oral list 10 minutes, second 8 minutes, and 2 minutes for rebuttal.
Yes, that's how I'm it. There we go.
Okay, good. So we're ready. You can begin.
Okay. Dear Justices, my name is Nsmcc and I'm here with my co-counsel, Mr. Williams, who will be appearing on behalf of the applicant. I'll be addressing the unconstitutionality of Section 4 of the School's Code of Conduct as to how it violates their rights to privacy and basic education in terms of Section 14 and 29 of the Constitution. My co-counsel will be representing or addressing the unconstitutionality of the school governing body's decision as to how it violates Section 17 of the Constitution, and 2 minutes will be for rebuttal. Will the court find a brief summary of the facts helpful?
No, thank you, Counsel. You can proceed.
Thank you, Justice. The critical question before this court is whether the suspension of these learners was unconstitutional due to Section 4 of the School's Code of Conduct, thereby violating Section 14 and 29 of the Constitution, as well as due to the decision of the school governing body, thereby violating Section 17 of the Constitution. And to this question, the applicant has 3 submissions. Firstly, that Section 4 of the School's Code of Conduct violates the rights to privacy. Secondly, the School's Code of Conduct also violates the rights to basic education. And thirdly, the school governing body's decision violates the rights to peaceful assembly. Turning to the first submission regarding the violation of their right to privacy. The respondent searched the applicant's bag for the violating their right to privacy in terms of Section 14b of the Constitution. And even if the respondent may want to argue that Section 4 of the School Code of Conduct allows this, we can declare this section as invalid in terms of the Constitution, which states that any other law that is inconsistent with it shall be declared invalid. Furthermore, the police infringed the privacy of Eddie's communications by going through his phone messages. This led to Mbali, Eddie, and Crystal's arrest, thereby violating their rights to Section 9, 10, 14, C, and D of the Constitution. There was no evidence to prove that any of the applicants were responsible for destruction of property. So the applicant had their communications infringed due to assumptions and were also arrested. It is clear that the applicant's human dignity, their benefit, and protection of the law, as well as their right to privacy, has been violated. The respondent may argue that there is a limitation to the right of privacy. The applicant acknowledges that all rights in the Bill of Rights may be limited by a law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society as stated in Section 36 of the Constitution. However, if less restrictive means are available, according to Section 36(1)(e) of the Constitution, the applicant argues that less restrictive means are available and should be used. The less restrictive means are giving the learners a written warning and also contacting their parents afterwards. And by all means, if this doesn't work, then suspension is a possible solution. However, the respondent also has to be very clear about the suspension time period stated, and also ensure that we rely on the law of our country. The means mentioned do not violate the rights of any of the learners. These learners are considered as citizens of South Africa and therefore have the right to be equally entitled to the privileges and benefits of citizenship. Sorry, Justices, I'd like to drink some water. If there are no questions on my first submission, I'll now proceed to address the second submission regarding the violation of the right to basic education due to Section 4 of the School's Code of Conduct. The respondent only sees cell phones as a distraction, but not as a learning tool, and in that manner violates the rights of the learners in terms of Section 28(2) and 29(1)(a) of the Constitution, and Section 8(1) and 2 of the South African Schools Act, and also according to the case law, NEC for Education, KZN and others with February 2008, paragraph 61 and 98. Banning of cell phones is not in the best interest of learners, as cell phones can be used as a learning tool, and be allowed in schools with less restrictive means in cognition to Section 361E of the Code of the Constitution, and the learning process will still be maintained. Phones can be switched off or silenced during classes, placed on learners' desks where the educator can see them. This teaches them self-discipline as well as self-control, and be allowed to be on their phones at appropriate times, which is at breaks and after school, and this teaches them time management. For learners to learn how to use their phones appropriately is a vital life skill, which they have to develop before adulthood and before they enter their workplaces. The school's Code of Conduct does not provide the learners with an opportunity to be able to practice and acquire these skills, and thus this is not in the best interest of the learners' present nor their future, as well as the improvement of the learning process is not put into consideration. In addition to this, the school's Code of Conduct does not stipulate for how long a learner can be suspended for, thereby taking away vital educational time from the applicant in terms of Section 29(1)(a) of the Constitution and Section 91(e) of the South African Schools Act. The school's Code of Conduct is not specific enough in terms of suspension, and therefore this Code of Conduct states the interest of the school too broadly. All learners have a right to basic education, and by suspending learners because the school's Code of Conduct is too restrictive is violating their rights to basic education. In addition to this, a Code of Conduct must be adopted after consulting with not only the parents and educators of the school, but also the learners, according to Section 8(1) of the South African Schools Act. For approximately 100 learners to join this assembly, it is clear that learners were not consulted or not in agreement to this Code of Conduct. And with all that I've stated, it is crystal clear that Section 4 of the School's Code of Conduct is indeed unconstitutional. And if there are no questions on the last submission, my co-counsel will move on to address the final submission.
I have a question, Councillor.
Yes, yes, Justice.
That echo here, but anyways.
Sorry.
What about the fact that your clients agreed to this Code of Conduct? It wasn't imposed on them. They agreed to be bound by it. So should we then be interfering in something that they agreed to be bound to?
Your Justices, for approximately 100 learners to join this assembly, not all of them were in agreement to this.
But I mean, that's the law of politics or the law of democracy, that there has to be a representative. You know, where the situation that the school body took only 2 students, that's not reflective of the entire student body. But 100 is quite a large number. And surely in there is the common sentiment of all students in the school. So the same way that, you know, people vote for SRCs or prefects are used as representatives of a school, surely we can still apply the same principle to say that the students did agree.
Your Justices, couldn't the school have maybe used less restrictive means in their Section 4 of the School Code of Conduct?
But why wasn't this raised during the drafting of the school Code of Conduct? They could have raised this as a concern as a student body and say, we think this is a bit too restrictive and therefore it should be adjusted accordingly. And surely you wouldn't have had your clients being suspended over something that they agreed to.
Can the Justice please repeat that?
My point is, counsel, at the bottom line is, your client agreed to this. Why should we then interfere in something that they agreed to? If you're familiar with the principle of pacta sunt servanda, which is the sanctity of a contract, you are bound by what you agree to. So why should this court interfere? Even if we think that it's unconstitutional, it's not our business. They agree to it.
Your Justices, I absolutely agree with you, but in the fact it stated that this code of conduct was implemented immediately.
All right, that's fine. Thank you so much, counsel. If you are done and there are no questions from my learned colleagues, I'll allow you to give the floor to your co-counsel.
Thank you, Your Justice. As it please the court, I am Gina Rooms and I'll be speaking for a further 8 minutes to address the final submission and to conclude. We submit that the school governing body's decision is unconstitutional as it violates the rights of the applicant to peaceful assembly. The school governing body is suspending the applicants for holding a peaceful assembly, thereby violating their rights in terms of sections 9, 10, and 17 of the Constitution, and in terms of the case law of Satao and others versus Galva's case paragraph 53, as well as international law, Article 21 of the United Nations International Covenant on Civil and Political Rights, and Article 15 of the United Nations Conventions on the Rights of the Child. The applicants exercised their rights accordingly and were arrested based on assumptions. According to Section 35(3)(h) of the Constitution, all persons are to be presumed innocent until valid evidence is found. We can all agree that the Constitution is founded on the following values: human dignity, the achievement of equality, and the advancement of human rights and freedom. For learners to be arrested and suspended due to voicing their concerns, how can this be in accordance of advancement of human rights and freedom that our country fought long and hard for? There was a fire in the administration building, and Precious, Tatu, and Apiwe were arrested because they were the ones leading the protest the previous day. Then a burn is set alight near the teacher's car park, and Eddie, Mbali, and Crystal were arrested because of the messages found in Eddie's phone. But in both incidents, no culprits were identified by the police, so there is no evidence that these learners were responsible for the destruction of any property. Therefore, the applicants still have the constitutional protection and the benefit of the law, and these arrests have tainted and taken away the human dignity of the applicants. In addition, Section 28(1)(g) of the Constitution states that every child has the right not to be detained except as a measure of last resort. Surely the police could not have accepted arrest as the last resort. The learners' parents could have been contacted immediately versus them being arrested and their human dignity being violated. We must remember that the applicants are minors and a child's best interest is of paramount importance according to Section 28(2) of the Constitution. In addition, the applicants assembled for a lawful purpose and the school governing body still suspended them for the maximum period. Again, the maximum period is left undetermined, thereby violating their rights in terms of Sections 9(1)(e) of the South African School Act and in terms of the case law of Satao and another versus Gava's case paragraph 52. The applicant had a lawful purpose not only to stop the ban of cell phones, but also to stop corporal punishment which the respondent allowed to be applied. And the purpose to stop corporal punishment was achieved. The respondents were aware of the wrongfulness of the actions and put a stop to corporal punishment. With all these facts taken into consideration, it has been demonstrated that the school governing body's decision was unconstitutional. The state must respect, protect, promote and fulfill the rights in the Bill of Rights. The school governing body is no exception. If there are no questions, I will now proceed to give a summary of our arguments and to conclude.
Council, I have a question.
Yes, Justice.
Council, you mentioned the Gavas versus Satau case. Insofar as that case is concerned, it dealt with the provisions of Section 11 of the Regulations of Gatherings Act, particularly the liability of the convener of the protest, where a protest results in damage to property of third parties. How does this case then fit into your facts? Can you just take me through that? What is the relevance of this case to your facts?
Okay, Justice, may I please answer your question after consulting with my co-counsel?
That's fine, Counsel.
Actually, I think it best that if there's no answer to the question, that council should just proceed and acknowledge that there's no answer to the question.
Justice, there is an answer. My answer is that the people who lead the protest should not be responsible for any destruction of property. I'm not sure if it, and that is the relevance of this case versus our case, Justice. I'm not sure if you understand.
But Counsel, in Gavas versus Satau, the court actually found that the relevant provisions of Section 11 of the Regulations of Gatherings Act 25 of 1993 are actually constitutional to the extent that they protect innocent and third parties from any riots that might result from protests. I think you are putting it the other way around. But it's fine, Counsel. You can proceed. It's fine.
Justice, I couldn't really understand your question, but I'll proceed to continue.
Yeah, my question was, how is this case relevant to your facts? That was my question, because the case speaks about Section 11 of the Regulations of Gatherings Act, insofar as it permits for the holding accountable of a convener of a gathering if a gathering results in a riot that ends up leading to malicious damage to property. So what it means is that in that case, what it means is that the convener of the gathering, the person who initiated the protest or the assembly, can be held delictually liable for a protest that led to the malicious damage to property of any other person, be it a car, be it an immovable property or whatsoever. So I was asking, what is the relevance of that case to your facts? How does the case
Justice, I want to refer to a similar case which happened in the United States of America during 2020, in which the protest leader, Ray McKesson, was held accountable for objects being thrown at an officer. The judge in this case ruled that there were First Amendment concerns with regards to Ray McKesson's rights. According to international law, Article 19 of the Universal Declaration of Human Rights, every person has the right to freedom of opinion and expression, and the applicants argue that therefore, due to these learners being leaders in a protest that they have the right to lead, should not be held accountable for the actions of the other learners, Justice.
Thank you. Through you, Chief Justice, can I ask a follow-up question?
Let's just also find out how are they doing on time, Justice Bum?
Go ahead, Justice, I couldn't hear.
The question was addressed to my colleague.
We have less than a minute.
All right, so I will allow that my colleague asks the question, and then I will allow you to answer the question, and that will be the end of your submissions, and then we'll move on to the respondent.
Yes, Justice, that's fine.
Okay. Thanks for that, Counsel. Thanks for referring us to that American case law that you've just mentioned. But my question is that now, does this court have any power to consider or entertain foreign law? Do we have any guiding principle that says this court can entertain foreign law? Because that's, you've just referenced a foreign case.
Yes, Justice. South Africa signed a treaty, which means they are bound by all the international laws.
Counsel, the case is not international law, it's foreign law. So I want to understand, do we have any guiding principle that will allow us to entertain that case and actually apply it in our jurisdiction?
Oh, Justice, but South Africa ratified, signed the treaty, and has agreed to be bound by foreign laws and its provisions of the United Nations.
I think yes, I think it's fine.
Yeah.
We understand.
Yeah, thank you. Yeah, we are. Yeah, thank you, counsel. Thank you.
Line of questioning as well as the response. Thank you so much to team.
Thank you.
Mute yourselves. Respondents, you're welcome to take the floor.
Thank you, my justices. As the court pleases, I am Pili Lenene, and I'm here with my co-counsel Tutu Wondlela. We appear on behalf of the respondents, and we have 20 minutes in which we both will speak for 10 minutes per counsel. I'll be dealing with the first part of our argument, which is based on Section 29 of the Constitution of the Republic of South Africa, which is education, and also environment, which is Section 24, and also the limitation of rights, which is also Section 36 of the Constitution. And he'll be dealing with the second part of our argument, which is based on the unlawful protest that the learners formed in terms of Section 3 of the Regulations of Gatherings Act number 205 of 1993, and also Section 4 of the School Code of Conduct, which deals with prohibition of cell phones at school. In this case, there are 6 learners who went against Section 4 of the School Code of Conduct, and they were all suspended. They then decided to challenge the school governing body's decision in High Court, arguing that their suspensions were unconstitutional as they are merely exercising their right of peaceful assembly. The court ruled in favor of the respondent. After their leave to appeal was refused in the Supreme Court of Appeal, they then decided to appeal the decision of the High Court in this court. The question before the court is whether Section 4 of the School Code of Conduct is unconstitutional and violates the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution of the Republic of South Africa, 1996. The counsel for the respondent therefore argues that Section 4 of the School Code of Conduct is not unconstitutional and does not violate the learner's right to privacy and basic education, and also that the school governing body's decision is not unconstitutional and does not violate the learner's right to peaceful assembly, demonstration, picket, and petition. Section 36 of the Constitution of the Republic of South Africa is the limitation of rights. As much as the learners had the right to express their feelings to education in terms of Section 16 and 29 of the Constitution, their protest was joined approximately by 100 learners, and that disrupted the process of teaching and learning, which could lead to a decreased school pass rate, as it is clear that the school sought to improve the school pass rate. If my justices will look at the case of Anthony versus governing body, Settlers High School in 2002, paragraph 17, it is said that the question should be asked in this regard, whether or not the prohibition is aimed at promoting positive discipline and whether or not non-compliance justifies punishment or some other form of sanction. This requires a spirit of mutual respect, and mutual respect may be in the learners abiding by the school rules.
So these justices further support the constitutionality of Section 4 of the School Code of Conduct, as it was also aimed at improving the school pass rate and promoting positive discipline. Since the learners were suspended, they decided to form a protest outside the school gates. Section 24 of the Constitution of the Republic of South Africa, 1996, is environment. And its paragraph A states that everyone has the right to an environment that is not harmful to their health or well-being. And its paragraph B states that everyone has the right to a protected environment everyone has the right to a protected environment for the benefits of present and future generations through reasonable legislative and other measures that could prevent pollution and ecological degradation. And also Section 29 of the Constitution of the Republic of South Africa is education, and it stipulates that everyone has the right to receive education in the official language or languages of their own choice at a public educational institution where that education is reasonably practicable. So as soon as the learners started protesting and burning the dustbins, they made the environment unsafe for everyone that was there, because there was a possibility of fire escalating and burning the teachers' cars and also harming anyone that was there. And if that fire...
Okay, counsel.
Yes, my justice.
I think I can see where your argument is going. But what about these particular learners in question? What about their rights to education? Were your measures not a violation of their rights? And which is what they're bringing to this court. They're not really bringing that everyone else's rights have not been violated. And as Justice Bam is highlighting, you have 5 minutes left. So what about the rights of these particular learners in question? How did you preserve the best interest in this case?
My justices, the learners knew the school code of conduct, and they were aware that if they brought cell phones to school, there was a possibility of them being suspended and also their cell phones getting confiscated. And also, my justice, yes, the suspension of them was for a period longer than for a period of the rest of the year. But then the school and Miss Koza, the principal, later realized that they did make some mistakes. They did make some mistakes in punishing the learners, so they were willing to rectify their mistakes. My justice, may I continue?
Please go ahead.
Thank you. So as soon as the learners started burning the dustbins, they made the environment unsafe for everyone that was there, because if that fire did escalate and burn the teachers' cars, the process of teaching and learning would have been disrupted. And it also would have affected the learners who were not part of the protest, not only affecting them, but violating their rights to education, as they could have not studied or continued receiving lessons in an unsafe environment. My justice.
Sorry, counsel.
Yes, my justice.
In your earlier presentation, you said that the students engaged in an unlawful protest or assembly.
Yes,
what is an unlawful protest?
An unlawful protest is a protest that took place where a notice was not given, and also a protest that was not peaceful and violent.
Oh, okay, no, that's fine. Thank you, counsel. Thank you.
May I proceed, my justice?
You can.
Thank you. So as the respondent, we submit that we justifiable in limiting the right of the applicant, as it was for their own safety, because on their way to school, they could get marked and be hurt, and also to protect them from cyberbullying. And we also submit that the school was justifiable in limiting the rights of the learners, because it had to discharge its obligations in terms of teaching and learning, and it had to protect all the learners, including those learners who were not protesting. My justice is also the learners when protesting, they violated the rights of others in terms of my justice. I cannot see.
That is 2 minutes. That is 2 minutes.
Thank you, my justice. Also, my justices, when the learners were protesting, they violated the rights of others in terms of section 21, which is freedom of movement and residence, subsection 1, which stipulates that everyone has the right to freedom of movement. So the learners, when protesting, blocked the road, making it unavailable for other learners to reach to school and also employees to get to work. And also, my justices, if there were an emergency, if someone in a crucial state had to be rushed to hospital, they couldn't pass because the learners blocked the roads. My justices, we submit that the respondent therefore did not act unconstitutionally or violate any rights of the learners. If, my justices, there are no further questions, I would like to hand over to my co-counsel, Dutu Wondlela.
Thank you, First Speaker. On behalf of the respondent, we'll hear from your co-counsel.
Thank you, my justice.
As the court pleases, I am Dutu Wondlela, co-counsel of Pinilenene, and I'll be dealing with the second part of our argument under the respondent. Now, I'll be addressing two issues. The first is the unlawful protest of the learners in accordance with Section 3 of the Regulations Act number 205 of 1993. And the second will be the Section 4 of the School Code of Conduct, which is the prohibition of the cell phones from the school. Now, your justices, after the learners were evicted from the school premises, they decided to form a protest outside the school gate. Now, your justices, they didn't issue out a notice to the school that they were going to protest. And if we look at Section 3 of the Regulation of Gatherings Act, now, if we look at Section 3 of the Regulation of Gatherings Act, its subsection 1 states that a convener of a gathering shall give notice in writing signed by him of the intended gathering in accordance with the provisions of this section. So as the learners decided to indulge in a protest without issuing a notice to the school, it was the same as committing a criminal offense. Because if we look at in the case of Lungwan and other versus and another in 2019, which was ruled in the Constitutional Court, in paragraph 16 states that if a gathering proceeds without a formal notice, then section 12, subsection 1, paragraph 8 provides that it is a criminal offense to convene a gathering without the requisite notice as prescribed in this act.
So, sorry, counsel.
Yes, Your Justice.
Counsel, I think you are misleading this court. In the case of Umlungwana, the Constitutional Court found that failure to give notice prior to a protest is not a criminal offense. I think you are misleading this court by saying that the Constitutional Court found that if one does not give notice, then that is a criminal offense. If you look at the Mlungwana judgment, section 12, subsection 1, paragraph A of the Regulations of Gatherings Act was found unconstitutional to the extent that it criminally punishes a convener for failing to give notice. And I think you are misleading the court, Mr. Ndlela.
And just to add on to my learned brother's comment, I think also given that this gathering was just of 6 pupils, is it not a bit too stringent to ask 6 pupils to hand in notice? I mean, if it were a gathering of 100 students, that's a completely different criteria altogether, but just 6 students are really virtually harmless.
Yes, Your Justice. We accept that the first protest did not require notice, but we also submit that there were still other protests that were formed at the learners. There was a second protest, and then there was a third one. The second one was joined approximately by 40 other learners, and the third one was joined approximately by 100 learners. So these two protests, the following protests, they were supposed to give a notice for this process, because also this process was not formed spontaneously.
Counsel, can you address my concern with the Mlungwana judgment? I still stand that you are misleading the court. That's not what the Constitutional Court found. So can you address my concern there?
But you are okay. Yes, Your Justice. But I recommend that if we look carefully at the Mlungwane and others versus another, which was in 2019 in the Constitutional Court. If we look at paragraph 16, it states clearly that if a gathering proceeds without a formal notice, then Section 12, subsection 1, paragraph A provides that it is a criminal offense. So, Justice, I'm not sure how I'm misleading the court.
Counsel, that is in paragraph 16, the court was stating what Section 12(1)A states. But if you look at the judgment, the Constitutional Court found that this very same section is unconstitutional. So what it means, counsel, in simple terms, it means that failure to give a notice is not a criminal offense. So can you address me on that? Why are you still insisting that it is a criminal offense because they didn't give notice? Just address me on that, counsel.
Well, it's because, Your Justice, also there was a banning of the dustbins and the other 2-second protests were not formed spontaneously. And they should have issued a notice for the other 2-second strike, for the other 2-second protest.
Okay, no, it's fine, counsel, you can proceed.
Okay, Your Justice. Thank you. Thanks, Your Justice, for the question. Also, Your Justices, if we look at Section 1, paragraph A of the Regulation of Gatherings Act, it defines demonstration as a demonstration of less than 1 people, but not more than 15 people. So, as we know, approximately 100 learners joined the protest, thus making the protest unlawful or illegal. Now, Your Justices, if this court also look at the case of South African Transport and Allied Workers and another business governors and others in 2013, which was ruled in the Constitutional Court, in paragraph 53, it was stated that nothing said thus far detracts from the requirement that the rights in Section 17, which is assembly, demonstration, picket, and petition, must be exercised peacefully. And it is only when they have no intention of acting peacefully that they lose their constitutional protection. Now, Your Justices, we argue that the learners' protest was no longer peaceful as there was a banning of the dustbins and there was a blockage of the road. Now, Your Justices, so in summary for our argument, we as the counsel for the respondent have shown that Section 4 of the School Code of Conduct does not violate the learner's rights and is constitutional since it was only aimed at maintaining a well-disciplined and purposeful school environment. So we as the counsel for the respondent, we therefore humbly request this honorable court to firstly declare that the High Court was correct in finding that there was no violation of the learner's rights in terms of Section 14 and 29, which is privacy and basic education. And to also rule that the SGP's decision does not violate the learner's rights in terms of Section 17, which is assembly, demonstration, picket, and petition of the Constitution, since the learners didn't give a notice for their protest. Now, Your Justices, these are our submissions before this court. If there are no further questions.
Thank you, counsel. On behalf of the respondent, we will hear from the applicants for their rebuttal now.
Thank you, Justices. We as the applicants still argue that our learned colleagues need to take into consideration that these learners are minors. In South Africa, many learners walk to and from school. We know South Africa has a high crime rate, so phones are required in case of emergency. That's all, Your Justice.
Counsel, can I ask you something? You said that South Africa has high crime states and therefore cell phones are needed because learners walk to school. Doesn't that then make them, doesn't having a cell phone open them to crime because people might want to rob them because they have cell phones?
Well, Justices, thank you for the question. Since the learners have phones, they will know how to use it appropriately. So they will know when to keep it in their school bag, the labels, and if there's an emergency, then they can use it to make phone calls. A person who can't see a phone won't know if they have a phone or not. If that answers the question, Justice.
Yes, it does. Thank you, counsel. Thank you.
All right, thank you so much to everyone. I take it that my learned colleagues have no questions to pose to you all. And with that, I declare this court as being adjourned. From here, I think it's just a matter of we're done. I'll stress in the steering committee, am I welcome to end this session and wait for the next one?
Mati, I think I have a comment for the teams, just a general comment.
Please go ahead.
Although I know we're not expected to give specific comments, but the last team, I was really impressed with the mode of answering questions. I bet sometimes when a judge is asking questions, they are not out to make you lose focus. They are only trying to help you make a case and also bring the proper facts and even the law to the fore. So I also think that sometimes the judge is just trying to give you a clue, and it will be wise that you take the clue when such clues are given to you on a platter of good, like it was done today. So yeah, that's just what I want to say. But overall, it was a very beautiful presentation, and yeah, well done.
Thank you, Justices, for your feedback.
Thank you, Justice Fam. And she really did raise something that's very important to take note if you do advance to the next stage. Questions are your friends, they're not your enemy. Welcome them with open arms. And don't also be afraid to say, I don't know. No one hold it against you. But now if you try to bend what you don't know to make it something, then you're caught out. All right, I'll straighten the steering committee. Do we have you? Are we able to
Bertha, who will be speaking for 9 minutes, and their second speaker will be Aluto, who will be speaking for 9 minutes, and they will be reserving 2 minutes for rebuttal. My co-judge, Leswalo, please confirm that you have also received that. I see the respondent has also communicated that the respondent, Oralist 1, Molobedzi, will be speaking for 12 minutes, and Oralist 2, Boyi Busisiwe, will be speaking for 8 minutes.
Yeah, Justice Matthews, I have received the time allocations, and I will be keeping time, and I will notify the teams of that time.
Thank you very much. And that, with that being said, I think we may commence with the proceedings. The first speaker for the applicant, we are ready to hear submissions from you. Thank you.
As it pleases the court, I am Bertha Mutsakani, and I'm here with my co-counsel, Aluto Luwata, and together we represent the 6 learners of Mjondolo Combined School, the applicant. I will be arguing that Section 4 of the school's Code of Conduct is unconstitutional as it violates the learner's rights to privacy and basic education in terms of Section 14 and 29 of the Constitution. My co-counsel will argue that the SGB's decision is unconstitutional as it violates the learner's rights to peaceful assembly in terms of Section 17 of the Constitution. I will exhaust 9 minutes of the court's time, leaving my co-counsel with 9 minutes for her argument, reserving 2 minutes for a rebuttal. The counsel for the applicant making use of the Constitution, South African Schools Act, and articles will prove that Section 4 of the Code of Conduct is, however, indeed unconstitutional as it violates the learner's rights to privacy and basic education. The counsel for the applicant finds Section 4 of the Code of Conduct is, however, unconstitutional and irrational. Quoting directly from the school's Code of Conduct, it stated that any learner found in possession of a cell phone will have that cell phone confiscated. Your Justice, that statement is very clear. However, the statement preceding this one stated that and may be suspended. Now, maybe implies that there's a possibility that a learner might be exempted from suspension although found in possession of a cell phone. Paragraph 175 of KwaZulu-Natal and other versus Pillay of 2008, ordered by the Constitutional Court, stated that the Code of Conduct did not contain any express provision for exemption, either to regulate in what circumstance they would be granted or to establish a procedure whereby exemption could be obtained. Now, this fact is true as this Code of Conduct did not give clarity as to under what conditions will a learner be exempted from suspension, although found in possession of a cell phone, and as to under what conditions will a learner not be exempted from suspension, although found in possession of a cell phone. The Code of Conduct is implemented with immediate effect. Now, we allege its irrationality as it did not comply with Section 8, subsection 1 of the Constitution. It states that a governing body must adopt a Code of Conduct for the learners after consultation with the learners, the parents, and the teachers of the school. Section 5.1b of the Schools Act of 1996 states that learners must be involved in the formulation of school rules. Your Justices, if truly the learners of Mjondolo Combined School were involved in the formulation of Section 4 of the Code of Conduct, we would not be here to contest its constitutionality or its fairness. Mjondolo Combined School lacked discipline, hence the Code of Conduct. With reference to the consideration of adopting a Code of Conduct, which was recognized by the South African Schools Act of 1996, it states that a Code of Conduct must not be punitive or punishment orientated. We submit, your Justices, that Mjondolo Combined School was rather mainly focused on punishment, as teachers were now making use of corporal punishment, learners were being punished for the smallest transgressions, and all 6 of the learners were suspended. Paragraph 17 of Antony versus the governing body of 2002, ordered by the Constitutional Court, stated that the question should be asked in this regard, whether or not the prohibition was aimed at promoting positive discipline and whether or not non-compliance therewith justifies punishment or some other form of sanction. Your Justices will submit that cell phone carriage does not justify suspension for the rest of the year, as it only dismisses the learner's rights to education. Sfiso Tele is found with a cell phone, which is, however, confiscated. He is granted a disciplinary hearing, to which he does not succeed, as he is suspended for the rest of the year. Now, the 6 learners are found guilty of the exact same offense as Sfiso Tele, however, they are not granted a disciplinary hearing. Your
Counsel,
Justice, this is
quickly just interject there a bit. Is it necessary for the school to give the 6 applicants the opportunity to make representations, even though the rule was clear that they would be suspended if they were in contravention of the provision? So is there an obligation on the school to nonetheless hear them out, even though the code of conduct says you don't have to, you just suspend them?
Yes, Your Justices, as lawfully, despite what the Code of Conduct stated, the procedure of suspension, however, has alleges the school to grant the learners to make petitions of, or at least to justify themselves, of which they did not.
Proceed.
Thank you. Your Justices, this is absolutely unjust, as it violates their right, as everyone is equal before the law and has the right to equal protection. As it violates, Your Justices, everyone is equal before the law and has the right to be protected and have the benefits of this law into the Section 9 of the Constitution. Section 9, subsection 1E of the Schools Act state that a learner may be suspended after for a period not longer than 14 days. However, we find Nsmcc and the applicants were suspended for the rest of the year. This violates their rights to education in terms of Section 29, subsection 1 of the Constitution.
Apologies. I think we are mistaken there. Nsmcc was suspended for the rest of the year, yes, but that is not our concern because he's not the applicant. The applicants, the 6 applicants, were suspended for the maximum period. In accordance with the South African Schools Act, the maximum period of suspension that can be given by an SGB is 7 days. Should this court not assume that by maximum period, the facts are basically indicating that the applicants were suspended for 7 days in accordance with the law?
Your Justices, no. We submit that in the state of fact, when the Code of Conduct was implemented, the ruling was that they were suspended for the rest of the year, to which that's exactly what the counsel for the respondent at the moment is defending. So at this present moment, the learners were suspended for the rest of the year before they were given the maximum period.
Counsel, they were never suspended for the rest of the year. It was only Nsmcc that was suspended for the rest of the year. The facts are that...
Your Justice, permission to make reference to the fact.
Yes, definitely.
The 6 learners, the six owners of the cell phone are immediately suspended from the school for the rest of the year. This is on the second page, the 4th paragraph, the last sentence.
Thank you.
Permission to proceed. Thank you. We submit to this honorable court that a child's best interest is of paramount importance in every matter concerning the child in terms of Section 28 or Section 2 of the Constitution. However, this is not the case with the respondent, as now teachers were applying or making use of corporal punishment to which the respondent did not reprimand. To substantiate further, some of the learners who were suspended were said to be in grade 11, and we are all fully aware of the importance of the grade 11 results for provisionary acceptance in varsity. Now, due to absentia, the chances for failure are not far-fetched. Hence, therefore, they might have to repeat the grade, as knowing the state of fact that the state that they were going to grant them any extra classes during the suspension. The respondent dismisses the learners during school. Now, Your Justices, this is absolutely humiliating to the learners. The respondent was, however, harsh, as they should have dismissed the learners after school and allowed them to proceed with the day's lessons for that day, and then they commence with their suspension from the next day. The mere fact that the respondent was so quick to dismiss the learners immediately goes to show that this code of conduct has no regard for the learner's right to education or human dignity in terms of Section 10 of the Constitution, stating that everyone has inherent dignity and the right to have that dignity protected and respected. Section 8, subsection 2 of the Schools Act states that a principal or his or her delegates may conduct a search on a group of learners for dangerous equipment or dangerous objects rather, and illegal drugs. Ms. Khoza orders a bag search and 6 cell phones are found. Your Justices, cell phones are nowhere dangerous or illegal, and nowhere in the Code of Conduct or the Schools Act does it warrant a search for cell phones. Therefore, due to that reasoning, the respondent had violated.
Your time is up, unfortunately, Counsel. However,
Your Justice permission.
I will ask you one question and allow you 30 seconds to just wrap it up there. With respect to the right to privacy, isn't this right quite less protected when we are dealing with public spaces? So the right is not as strongly protected in public spaces, public institutions, public activity, as one would claim its protection in their own personal private realms.
I'm not getting the question.
Isn't it that the right to privacy isn't as strong when we are dealing with public spaces, and therefore the school was correct in limiting their right to privacy?
Your Justices, as the counsel for the applicants, we have to, we deny that reasoning. Despite the fact that the right to privacy is not absolute, the learners still are entitled to their rights to privacy, to which the respondent did violate, as the reasoning behind the search was not justified.
Thank you, counsel. You may now hand over to your co-counsel.
To my co-counsel.
Your Justices, with 9 minutes of analyzing issue two being the submission that the SGB's decision is unconstitutional and it does violate the learner's rights to peaceful assembly in terms of Section 17 of the Constitution. We submit that in accordance to Section 39, subsection 1 of the South African Constitution, it states, Your Justices, that when interpreting the Bill of Rights, a court, tribunal, or forum must consider international law. Reason being that South Africa ratified its treaty and has agreed to be bound by its provisions. With this being stated, we refer to Article 15 of the United Nations Covenant on the Rights of a Child that states that all parties recognize the rights of a child to peaceful assembly and freedom of association. Article 8 of the African Charter on the welfare of the child also states that everyone has the right to freely assemble with others. In accordance to paragraph 61 of the Satau and others versus Garvers and another that was ordered by the Constitutional Court in year 2013, it states that the freedom to assemble is central to our constitutional democracy. It exists primarily to give a voice to the powerless, which in this case, yes, Justice?
Paragraph 53, I think, of Garvers basically specifically says that right to, to petition, to demonstrate, to assemble, is subject to the requirement of peace. Can we say in this case that the protests were indeed peaceful, taking note of the fact that there were bins that were burned near the teachers' car park? There was an admin building that was set on fire. And so can we really say that the rights were exercised peacefully in this case?
Your Justices, I submit that some of the events that you have stated are one of which the police had investigated the scene and no culprits were identified. On the fact that it wasn't a peaceful assembly at the end, Your Justices, it is open for the convener in this case to state that it was never the intention of the strike that it becomes unpeaceful, Your Justice. All that it was just to discuss the unfairness of the situation. You're just.
Is it relevant for this court that you had no intention for violence to erupt, or is it sufficient that violence erupted and therefore that right is no longer protected?
Indeed, Your Justices, because one of the most important part of this is to hear the other side, which is the Audi principle. And in this case, Your Justices, we state that the respondent has continuously defied the rights for the applicants to fully express themselves. In the facts, Your Justices, it states that the applicant was resistant in all that the respondent had been setting, Your Justices, such as corporal punishment and punishment for small transgression. Your Justices are to...
Assist me here. How is the protesting and the suspension, how are these two reconciled?
Your Justices, if the respondent truly had the best interest of the applicants entrusted to them at heart as per section 28, they would have adhered to all the resistance and no protest would have occurred if the applicants felt they already expressed themselves fully, maybe in a disciplinary hearing, and therefore no protest would have been staged in the first place, Your Justice.
So are you saying that if I sell you a gun, you go murder an individual, I should be the one who's responsible for giving you the gun, but you are the one that actually murdered. So I should be responsible for your conduct?
Indeed, Your Justices, you knew exactly what would occur if you give me a gun, because one of the purposes of a gun is to murder someone, Your Justice. Those were your intentions.
I don't think so, counsel. I think we must assess whether or not I was there. Did I act? I did not act. I was not the one to pull the trigger. So I cannot be guilty of murder because I'm not the actor. And in every single thing, we need the person who did the action and the victim. When I give you a gun, I may be aiding you to do something if I have the knowledge that you will kill the individual, but I cannot be convicted as the murderer of the other individual. You are. So I want to know, on what basis are you shifting the blame here from the learners to the school? The school is the victim in my view, and the learners are the perpetrators. So how are you switching roles now? On what basis?
Your Justices, the school is a place in which the effective education can take place. The applicant has been in the school and has learned its morals from the school, as a school plays a certain role of allowing the applicants to acknowledge what happens in the real world, Your Justices. We also submit that many of the actions of the applicants are of the respondents, such as corporal punishments, which is a violent act. We can state, Your Justices, that the applicants learned from the respondent such violent actions, Your Justices. If it pleases the court, I will proceed. Your Justices, it is to these horrifying reasons that these learners met outside the school to discuss the unfairness of the situation, being that they were deprived of their right to assemble after being deprived of their right to disciplinary hearing, deprived of their right to non-enforcement of corporal punishment, and again violated of the Audi principle. We will bring it to the court's attention that Special Cele did not join the protest. Reason being that he had already expressed himself fully in a disciplinary hearing. Therefore, we state, Your Justices, that if the applicant too was given the same chance as Special, they would have not staged the protest as they would have fully expressed themselves already. Your Justices, there could be many reasons as to why this protest was taken in the first place. But if there's one thing the court would like, the applicants would like for the court to take into consideration, is that the pass rate of Umjondolo Combined School increased to 72%. We submit, Your Justices, that this increase was due to the fact that many of the learners aren't even on the system due to suspension. Now, Your Justices, we state that the applicant was unarmed in
Excuse me, counsel. That is quite an inference of facts that you are making there because it's nowhere in the facts. You are saying you want us to assume that most of the learners have been suspended, and that's why the average has been, going up. But what supports that conclusion? And so far as we know, we only have 6 students that have been suspended that are here, and 1 other student, and they have nothing to do with any other students. But in any event, suspended students are not exempted from writing exams. So in my opinion, if the student is suspended and they write the exam nonetheless, because they still have the right to write the exams, then it means the average would in fact be going down if most of them were being suspended. But in this case, the average is going up, which means none have been suspended, but for the ones that we know about. I see that you are really running out of time, so you can just briefly conclude, answer my question.
Your Justices, we need to consider the fact that the school never really stated that it would take part in decisions after the suspension. All it stated was that a suspension would occur. But in the Code of Conduct, it states that after the suspension has been Your Justice, if it pleases the court, I would respectfully request this honorable court in conclusion, counsel for the applicant humbly pleads with the court to declare that indeed Section 4 of the school's Code of Conduct is
You may assume that the court is familiar with the prayers. Thank you very much.
Thank you, Justice.
We will now hear arguments from the respondent. First respondent, you may proceed.
May it please the court, my name is Morobedzi Andisa with my co-counsel Busisiwe Boy, and we appear on behalf of the respondent. We humbly submit that the Code of Conduct is valid and does not violate the learner's rights in terms of Section 14 and Section 29 of the Constitution, namely the right to privacy and to education. We also submit that the suspension of the learners, as decided by the SGB, does not violate their right to peaceful assembly, but only limits it. My justices, when a school decides upon implementation of a school code of conduct, it is in the best interest of the learners. My justices, it was said in the head of Department of Basic Education, Free State Province versus Valcom High School and another, that our code must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. The school code of conduct does not violate the learner's right to privacy and to education.
On that note, if I may quickly just interrupt you a bit there, you're saying that it doesn't. But I mean, when you look at Sections 14 says to us, every person has the right to privacy, including the right not to have their property searched or their possessions seized. In our case, the learners' bags were searched, their mobile phones were confiscated, and in addition, they were suspended. How is that not a violation, a direct violation of the constitutional provision protecting the right to privacy?
My justice, the applicants did not have a reasonable expectation of privacy, which was objectively reasonable, meaning that by enrolling the learners to the school, that the school acts well within its local parentis role by confiscating and searching for phones in order to maintain discipline in the school.
The applicant has argued that that is applicable only in instances where we are dealing with searches that specifically relate to finding something that might be dangerous to the health and the safety of the students in the school or the staff in the school. How does a mere cell phone, become dangerous to the health and the safety of the students? What is the reasonable suspicion there to search the student?
My justice, a phone can be used for several things. It can be used for positive things and it can be used for negative things. Namely, a phone can be used to take videos of learners, of other learners. That's violating their right to privacy.
I understand, but I'm referring to the applicant submission. They say that the searches are only in situations where there's reasonable suspicion of a dangerous weapon that will cause harm or threaten the safety and of the safety and the health of the students and the staff. So how does a mobile cell phone pose threat to the safety and the health of students and the staff at the school?
Well, my justice, a phone does not affect the health and safety of a person, but rather it limits the other learner's rights to education, as the school will refer to past accounts where phones were used to disrupt lessons. Per Section 4 of the Code of Conduct, the use of cell phones, whether on or off, shall at all times be prohibited. Any learner that is found in possession of a cell phone will have the phone confiscated and may be suspended. My justice, this prohibition consists of three constituent elements, namely the use of a cell phone, the confiscation of the cell phone in furtherance to possession, and suspension for failure to abide by rules. The use of a cell phone, my justice, simply refers to possession. Possession is a central or person intentionally exercised toward a thing. Stated differently, there must be an intention to use the object in question. Therefore, the applicant was in possession of a cell phone with the intention to use it, thus disrupting lessons.
Yes, Council, apologies once again. And I think you all know my eagerness to engage with you. Would you, if you were in possession of a gun, say, without using it, you never used it, and you were in possession of it, is possession sufficient for us to infer intention of murder, for example? So basically the question is, just because you are in possession of something, should we assume that you have the intention to ill use whatever item you have with you?
Well, this refers us back to the definition of possession. There needs to be a reason to exercise the object in possession. Possession of a gun is not subject to unlawful.
Of the object, is the exercise of the object in question to be inferred as negative all the time? Why can we not assume the students were going to use the cell phones to call their parents to pick them up after school? Why can we not assume that the students were going to use the cell phones because they're going to allow them to induce their research skills while they're at school during break time, and so forth and so forth? All the good things. Why must the inference be the negative, that they want to disrupt the learning activities of the school, especially when we know from the fact that some of the cell phones were even off, and the cell phones, none of them were being used in class, so there was no disruption. So why must we infer to the negative?
My justice, if it was so that the learners were in possession of a cell phone with a positive intention, they should have, rightfully so, went to the principal of the school or the educators to report such possession of a cell phone.
Sorry, Council, can I ask something? Is there a provision in the school code of conduct that says that if a learner comes to school with a cell phone, they must declare that possession to the principal? Do learners have that avenue?
No, my justice.
So how would we have expected the learners to approach the principal and say, "Hey, I have a phone"? would not that have resulted to possession that could have led to them being suspended?
Well, it is not at all clear what assumptions we should bring up, but what is clear is that the learners did not make an effort to go to the principal. Therefore, there is no way for us to know what would have happened if they had went to report such possession.
Okay, thank you, Council.
Now, the applicant had constructive possession of a cell phone and stands in the same position as a person in actual possession of a cell phone. In this case, Sisokele was in actual possession. The respondent will rely on this act to infer that the applicant's possession of a cell phone was with the common intention, the intention to use. Therefore, the phone needs to be confiscated. The confiscation of the cell phone in furtherance to possession is the second element of the prohibition. My justices, the applicant did not and still does not have a reasonable expectation of privacy, which was objectively reasonable. Neither the confiscation nor the search of the school bags are infringements. Search, my justices, where it relates to a person must be given its ordinary meaning. Search, my justices, may also be regarded as any act whereby a person, container, or premises is visually or physically examined with the objective of establishing whether an article is on or upon such person or container. My justices, if there is no reasonable expectation of privacy, then no infringement has occurred. The applicant did not have a subjective expectation of privacy, which was objectively reasonable. The applicants have no reason to expect privacy as the school.
Arguments on the issue of reasonable expectation of privacy. What is your argument on the violation of their right to education and the fact that you suspended them without a proper hearing, which you are required in accordance with sections 9 of the Constitution of the South African Schools Act to give to them? Doesn't that mean that you suspended them irregularly, and therefore this court must set aside that suspension on the basis of irregularity?
My justice, it is as stated in section 4 of the South African School Act. Nothing contained in this act exempts a learner from the obligation to comply with the code of conduct attended by such learner.
I understand.
Let's
say the applicant concede that their students were in violation of the code of conduct, but nonetheless, for a suspension to be lawful by law in accordance with sections 9 of the South African Schools Act, that suspension, before the suspension, the students must be given an opportunity to make fair representation, what they refer to as the audi alteram partem principle. So doesn't that mean, since they were never given the opportunity to make representation before they were suspended, doesn't that mean that the suspension is unlawful? Sfiso Ele was given the opportunity to make representation, and so his suspension may be justified. But the 6 applicants were never given the opportunity to make representation. Doesn't that mean that their suspension is unlawful by law?
Your primary suspension is unlawful, but Ms. Khoza sends out, in the facts, Ms. Khoza sends out a message saying that she recognizes that the learners have the right to complain, but she still considers phones as disruptive, meaning that Ms. Khoza does see that the issue of her suspending the learners without a fair hearing was without following proper protocol.
Why did she not give the learners the proper hearing to rectify her mistake and to follow proper procedure? She didn't give them the right to make representation. So the suspension is still effectively improper.
Their primary suspension was what did not follow proper procedures.
Do we have primary and secondary suspensions?
Secondary suspension as for the suspension for their illegal protest.
For
their illegal protest.
Okay, so first you were saying that the primary suspensions were unlawful, right?
Yes.
And now you are saying that there is a secondary one, which is one now you are placing reliance on, right?
Yes.
But I assume that will be dealt largely by your co-agent.
Yes.
I will have questions for your co-agent. You may proceed to conclude your arguments.
Okay.
No, you can conclude your arguments and then hand over. You still have about 30 seconds, I think.
Lastly, suspension for failure to abide by rules. This means that the applicants are liable for a misconduct and a breach of the code of conduct. Suspension, my justices, serves as a form of exclusionary discipline. It promotes discipline and successfully modifies misbehavior before it even occurs in other learners. My justices, it teaches them that the world needs self-disciplined people and prepares them for the real world. My justices, if there are no further questions, I would like to hand over to my co-counsel.
Thank you very much. We may now hear from the second counsel for the respondent.
My justices, may please the court, would now like to move to the second submission of the respondent's argument. The SGB's decision to suspend the applicant is valid and constitutional and does not violate the applicant's right to peaceful assembly in terms of Section 17 of the Constitution. This decision of the SGB to suspend the learners after the protest they displayed outside the school premises is valid and constitutional. In this case, the respondent's decision cannot be considered as invalid or wrongful, as the decision merely limited the applicant's protest, for they infringed upon other learners' rights as well as public order, making it reasonable and justifiable in terms of Section 36, subsection 1 of the Constitution.
If I may just interrupt you there, and I think you should have been prepared for my questions, as I had indicated a bit earlier to your co-agent, that I will have quite a number of questions for you. She has conceded that in terms of the first, part of the prayer, the suspension might have been, a bit out of the way, but yours stands. And I need you to show me how your the secondary suspension is effectively legal. Did you give them the right to make representation? No. So it still seems to me that it like the first one, it's still quite flawed. But secondly, did you even identify them at the scene that you are saying they are responsible for? No identifiable culprits were found there. So how do we justify these suspensions?
My justices may please the court. I'll refer this court to the Mlungwana case, paragraph 28, which strictly emphasizes that Section 12, subsection 1, paragraph A of the Gatherings Act renders it an offense for any person, including children, to convene a gathering, including a peaceful gathering, in circumstances where there has been a failure to provide notice or adequate notice of such a gathering. Therefore, this was an illegal protest, for they had not given notice.
But it's not
counsel.
Justice Matter, you can go through, and I'll
thank you. Counsel, in terms of the Mlungwana judgment, you are misleading the court. The Constitutional Court found that Section 12(1)(a) of the Regulations of Gatherings Act 205 of 1993 is unconstitutional to the extent that it criminalizes a convener for the failure to give notice prior to a protest. So what it means, counsel, is that it is no longer a criminal offense to fail to give notice. So I think you are misleading the court, counsel. And what's your point on that one? Section 12(1)(a) is unconstitutional. It has been declared unconstitutional. It is not a criminal offense to fail to give notice. Can you address the court on that one?
If I may, perhaps you could note that question also down. If I may also just indicate that was the school, I just want you to clarify for me, was the school, are you saying that the school was effectively suspending the learners or on the basis of criminal charges? I mean, that is not within the ambit of the school's code of conduct. Why is the school suspending them for a criminal matter? Shouldn't the school be concerned about what it regulates in its own code of conduct and let police officials deal with the other issues?
My justices, this statement was not based on criminal offense, but instead the nature of the right, or instead not the nature of the right, but instead the relation between the limitation and its purpose, which I was supposed to submit later on, is that the limitation serves to maintain public order, the protection of the rights and freedoms of others, which are the freedom of movement and the right to education, as well as to prevent community disruptions that had been caused by the protest. We understand that the respondent did not allow or give the learners a chance to a fair hearing, but instead it's not justifiable for them to limit other people's rights or even cause infringement and community disruptions for the people in the neighborhood. And may the other justice please repeat his question? I'm afraid I'm not familiar with it anymore.
Counsel, my question started as a statement. I put it to you, Counsel, that you are misleading this court. Now, can I direct Counsel to paragraph 112 of the Mlungwana judgment? If it's not before you, I'll read it to you, Counsel. It reads that the declaration by the High Court that Section 12(1)A of the Regulations of Gatherings Act 205 of 1993 is constitutionally invalid is confirmed to the extent that it makes the failure to give notice or giving of an inadequate notice by any person who convened a gathering a criminal offense. So what it means here, Counsel, is that it is no longer a criminal offense to fail to give notice. So now your submission that the protest is unlawful because the protesters failed to give notice is misleading to the court. So can you address the court on that?
My Justices, counsel for the respondent would love to apologize for being legally imprecise.
Thank you, counsel. Noted. On a side note, I would advise counsel to look at the provisions of Section 5. The provisions of Section 5 of the Regulations of Gatherings Act.
Now, my Justices, if it pleases the court, would now like to move with our submission.
All
For
right.
errors said in the Govers case of South African Transport and Allied Workers Union, Satao and others versus Govers and others in paragraph 53 that, and I quote, nothing said therefore detracts from the requirements that the right in Section 17 of the Constitution must be exercised peacefully. And it is important to emphasize that it is the holders of the right who must assemble and demonstrate peacefully. It is only when they have no intention of acting peacefully that they lose their constitutional protection. The counsel for the respondent would like to submit to this honorable court that the limitation to the applicant's right to assembly is reasonable and justifiable for the following reasons based on the limitation clause as per Section 36 of the Constitution. Firstly, the nature of the right. The counsel acknowledges that the right to assembly, demonstrate, picket, and petition is a fundamental right, but it is not absolute. This means that it can be limited by this section and other sections of the Constitution. Secondly, the importance of the purpose of the limitation. The limitation is enforced to maintain public order outside the school, as well as create a productive learning environment. The limitation is used to show that irrational behavior, which in this case is the learners' protest that infringe the rights of the SGB to association, as well as the other learners' rights to basic education, does not solve the problem, but instead makes the matter worse. The limitation prepares the applicants for the outside world, which demands critical and rational thinkers. Fourthly or thirdly, the nature and extent of the limitation. The applicant's right to freedom of assembly is limited in this case. Their right to protest, though spontaneous, causes major complications and therefore creates a reasonable and justifiable reason for limitation. Fourthly, the relation between the limitation and its purpose. The limitation.
Sorry, counsel. Sorry to cut you, counsel. I really apologize. What complications does a spontaneous protest cause? Can you just maybe give the court maybe 2 examples?
Freedom of movement, as well as the freedom of association, as it hindered the SGBs to association to discuss the matter.
Thank you, counsel.
And lastly, less restrictive means to achieve purpose. In this case, my justices, it is suspension. The applicant's right violated the rights and freedoms of others, and as a sanction has been imposed for this offense. The respondent's decision to extend suspension for the learners, therefore, is less restrictive than the actual limitation. My justices, the code of conduct serves as a beacon of preferred discipline at the school with the aim of modifying behavior to ensure better and noticeable results. The suspension of the learners due to the mismanagement of their right to assembly serves as a lesson to other learners that irrational thinking has profound consequences. In light of the arguments advanced and authorities cited, the respondent humbly pleads before this honorable court to, firstly, declare the High Court as correct. Secondly, through the respondent's decision to suspend the applicant does not violate their rights to education. And lastly, to rule that the school's code of conduct is constitutional. However, if the court should find it unconstitutional, the applicant must serve their secondary suspension for illegal protest, or instead for their protest. For this act of kindness, the respondent sanction shall be duty bound forever. If it pleases the court, the counsel for the respondent would now like to take their leave.
Thank you very much, counsel. We will now hear rebuttal from the applicant.
I think that our counsel is muted.
Yes, you are muted. You are muted, Bertha, sorry.
Oh, apologies, Your Justices. Would like to quote directly from the contender. They stated that Principal Khoza then called for a meeting to then rectify the mistakes. Your Justices would like to submit to this honorable court that to begin with, would like to allege that the respondent should have, however, applied the Ubuntu principle, saying that this was the applicant's first offense and that this was the first time that this code of conduct was being implemented. Therefore, they should have just given room for change or for improvement in that. Secondly, would like to speak about Section 36, subsection 1, which speaks about having a less restrictive measure. If the respondent truly did care about the learner's right to education, they would have found an alternative way of altering this whole thing and not suspending the learners entirely to their rights or to their right to education. Your Justice, as I submit to this court. If the court permits, may I please take my leave?
Thank you, counsel. Thank you very much. I will now allow my learned colleagues to give you some brief feedback. I am assuming that this is your last session of the semifinals, as it is the second session, and I do wish you all the best. I will start with Justice Letswalo. Justice Letswalo, would you please just give the teams some brief feedback, general feedback?
Thank you, Justice Matthews. I think that both teams did well. The oral arguments were really good. The answering of the questions was really good. The questions were engaged with properly and thought of properly. However, I would like to caution the teams going forward with regards to time. I was indicating the time on the camera. I'm not sure if you saw me, but I kept on indicating the time. And when your time was up, I put the stop banner. So when your time is up, you don't just speak. You have to ask the bench for more time to proceed to speak instead of just going on and on with your submissions. And yeah, that's all I would like to say. Thank you.
Thank you very much, Justice Letswalo. May I kindly request Justice Malemacha to basically also just hand out some brief feedback for the teams.
Thank you, CJ, and thanks to both counsel from the two respective teams. I think they both argue very well and they engage with the questions. I just need just a little word of advice. They must just check the case, the Mlungwana judgment. They really need to check what that judgment really stated or what the court found in that case. But other than that, and also I just found that all the teams, I think the ladies are in a rush to close their submissions. They all speak so fast. I don't know, maybe it's their nature, but if they can just slow their tone down, they're really doing well. They don't need to panic. They're really doing well, and good luck in the next rounds.
Thank you very much, Justice Malemacha. I will close up the session with a very brief commentary myself. I think I have been in session with all of the teams, both participants, both teams. I think you guys have been in my courts before. And you know, I love to engage, and you know, the reason I love to engage is because a moot is a conversation between you and your judges. And also because, you know, I have been dealing with these facts from the very first day. Before you got the facts, I had already gotten them. And so it is almost impossible for me to sit and not ask any question, especially factually, because I'm also very familiar with the facts. However, I am very impressed with the progress that all the teams have made thus far. Both of you did exceptionally well. I think perhaps moving forward, if you are going to be moving forward in the finals, obviously you will have a session with me and some of your coaches when we coach you for the finals, if you do proceed for the next round. In fact, as a matter of fact, I think if any of you are debaters, you can take this, into account for any future reference competitions, whatever. It is good to make concessions sometimes, as long as they are strategic, as long as you can come back and show that the concession that you have made is not fatal for your argument, for your side. It is very important that we understand as your bench that yes, you have made a concession, you agree that this happened and it's wrong, but it is not fatal to your argument. It is not fatal to your case, and you proceed to show us how it's not fatal to your case. I think that is the one thing that I have found a little bit lacking in most of the teams that I have been adjudicating, including the teams we had now. Strategic concessions are okay. Because sometimes you will find a bench that will not want to move on. They will want to drag you back to that one thing that they know is your weakest point in an argument. But it is very important that you have an alternative submission that says, fine, if the court is not accepting my argument insofar as it relates to this particular thing, here's my next argument. Why? Because the first one was not fatal. So I think it is very important that we as teams remember that. So if any of you will be moving forward, I really wish you guys all the best. I have thoroughly enjoyed myself. I have been factually and legally engaged throughout the competition, and I really, really appreciate your efforts. All the best moving forth. I think you can go and wait for us in the waiting room, in the main room. I'm not sure if the announcement for the finalists will be today or tomorrow morning. As you know, it is quite difficult to manage all these things with all these judges, and me, myself, also, I am judging here, and I still have to manage all the other courts. With Sis Joyce, I think, was here. I'm not sure if she's here anymore. It's just, me, Sis Joyce, and Brafil, and we are managing all the judges' scores. So, yeah, quite a lot of work. But otherwise, I wish you guys all the best. You can wait for us in the other room. We will be in contact, and then we will alert everybody in the other room, in the main room, whether or not the results are to be announced today or tomorrow. Thank you very much. Bye-bye.